All right, I'm going to go ahead and get started here, and we'll talk about technical things in a moment as well. We're currently being recorded, just FYI, just so everyone knows that we are, these proceedings are recorded via video and audio recording using Microsoft Teams. Let me go ahead and read my introductions for today. For the record, today is Wednesday, February 21st, 2024. This hearing is being conducted both in person and telephonically or virtually using Microsoft Teams and is currently being recorded. If you have technical difficulties or for some reason get disconnected and are not able to rejoin the hearing, please contact Kawana Barbie, and I'm about to give you her phone number. Her phone number is area code 615-747 5386. If someone is disconnected, who's a party to the hearing, we will do our best to reconnect with you. You can also email me. We have a link to this meeting on our website as well under our calendar page. So if you need a new link or something like that, it's also on our online. We'll get you back in. We won't go on without you. We are present before the Tennessee Assessment Appeals Commission, who've been appointed by the State Board of Equalization to review initial decisions and orders or of administrative judges and other related matters. My name, for everyone speaking, you can see me on camera. I'm down here in the bottom right-hand corner. My name is Robin Pope. I currently serve as the Executive Secretary with the State Board of Equalization. It just means I'm the director here. My role today is to sit with the Assessment Appeals Commission as a hearing officer. As a hearing officer, I will preside at this hearing, rule on questions of the admissibility of evidence, advise the commission members as to the law of the case and otherwise on procedural issues, and otherwise ensure the proceedings are carried out in accordance with law. I specifically do not participate in the decision-making of the commission. The decision is made by our 3 panel members here on my left. Their decision is all their own. I don't participate in their decision. I'm not a voting member. I don't have a vote in what happens today. My role is predominantly just to make sure that we have this hearing, it's scheduled, the parties are here, everyone has access, and otherwise make sure that we're following the proper procedure for everything. I'll now go through and make several introductions before outlining kind of the next steps for our day. All right, we have our presiding members. I'll start with our presiding member, Mr. Phil Russ, on the far right.
My name is Phil Russ.
That go through.
My name is Tim Profit.
Say it one more time. It's your microphone. The button.
Got green on there. Hello? Hello? Okay.
Those are our commission members. For everyone on virtually, we do have quite a few of you. If any of you are not able to hear any of the commission members or think you're missing audio, please interrupt us. Just let us know. Say, hey, I cannot hear something. Okay. It is just important.
I'm sorry, I missed the on the left-hand side, the name.
Yeah, Mr. Bowles, could you try that one more time? Make sure we can hear you.
Hello? Hello?
Yes, sir.
Hello. Can you hear me?
Good morning.
Yes, sir.
Good morning.
All right, and that's Commission Member Van Bowles. All right, during deliberations, across from me is a counsel with the State Board of Equalization, an attorney with the State Board. He's going to assist the commission with questions during deliberations and ask them, offer any guidance regarding the legal sufficiency of any of their conclusions. So if they have any legal questions, he will be the person they will really ask. I generally chime in for procedural questions. Importantly, during deliberations, myself and Mr. Childress will be the only people who are able to speak with the commission. Once we enter deliberation, further communication and questions between the parties and the commission must cease. If they have a question for the parties, they can reopen the record at that time. It is somewhat odd. You will get a decision today from the commission. You will hear their decision in their deliberations on the record. You will then receive a written copy of their decision within 90 days of today's hearing. All of the appeals to be heard today are to be conducted based upon the record available before the administrative law judge during your prior hearing. Pursuant to Tennessee Code Annotated 67-5-1506, that's before it was amended into 2023, the Assessment Appeals Commission may affirm the decision of the hearing examiner. That is, they can affirm the decision you already received, or they can remand the case back to the administrative judge. The commission may reverse part of that decision from the administrative judge if they find that your rights, that's the rights of the petitioner, have been prejudiced because the administrative judge's ruling, finding, inferences, or some sort of conclusion, something about their decision was either 1, in violation of constitutional or statutory provisions, 2, made upon unlawful procedure, 1, in violation of constitutional, statutory provisions. Essentially, what they're looking for is, did the judge follow and apply the law correctly? Did the judge follow the law of appraisal correctly in this framework? 2, made upon unlawful procedure. That is, did the judge not follow some proper procedure, or was there some sort of abuse of procedure that prejudiced your rights? 3, was the decision of the administrative judge arbitrary and capricious or characterized by an abuse of discretion or clearly unwarranted exercise of discretion? So that is somewhat more self-explanatory, but essentially, was the decision you received just totally arbitrary or an abuse of discretion? And 4, was that decision unsupported by evidence that is both substantial and material in light of the entire record? In determining the substantiality of the evidence, the commission today can take into account whatever in the record fairly detracts from the weight of a finding of fact, but shall not substitute their judgment for that of the hearing examiner as to the weight of the evidence on a question of fact. So what I usually kind of try to explain this to mean is for our commission members, if the judge found that the house was blue, the commission members can look at photographs of the record and they may say, well, maybe to me it looks a little green, but the judge found it was blue. And so for all intents and purposes, blue is the color of the house. They're not required to ignore that maybe someone called it teal and someone called it, azure or something like that, or someone called it red. However, they're not able to replace their judgment for that of the judge. The judge said it was blue, and so therefore the house was blue as a finding of fact. But they're free to look at the entire record, essentially. They're not reweighing the evidence, but they are looking at the entire record. This means that today there is no new evidence or additional facts. There's no new testimony. There's no new documents. There's no nothing new being presented to the commission. We are here today to hear oral argument. That's argument from you as the petitioners and respondents as to why you believe the decision of the administrative judge was decided correctly or incorrectly. So you'll notice no one is being asked to swear in or offer testimony or being told, are you going to swear to tell the truth? There's none of that today because we're not hearing any testimony. We're just hearing arguments about that initial decision and order and kind of why you believe your rights were prejudiced because of that order. Before each case today, I will read an entire copy of the initial decision and order into the record, since that is what we are here to review. Generally speaking, these proceedings are pretty informal. We will start with one case at a time, and we will proceed to each next case immediately thereafter, taking breaks only as necessary. We will start with the petitioner, that is the appellant, the person who filed the appeal to the commission, and then we will have the opportunity for the respondent or the appellee to make their reply, and then we will end with the same appellant for any final comments. We have 3 cases on our docket today, that being, and this is read in no particular order. I have 10 Roads Express versus the Office of State Assessed Properties. I do see Ms. Throneberry in the gallery online, and I have Mr. Sharp in person here. We have Jesse and Priscilla Chung, I believe, versus Shelby County Assessor's Office. I see both of you on the call as well. And then finally, we have Miss Kelly Plants versus Jefferson County, and I believe I see both of you on the online as well. So generally, I try to go from the appeals that whoever thinks they're going to take the shortest amount of time first, and then proceeded to our longest. And so I'm going to go through that list again. Have you introduce yourself, just so we know we can hear and see you. And then I'm going to ask you how long you think you will need to present your arguments. I'm going to start with, I guess, 10 Roads Express and Ms. Throneberry. I apologize if I mispronounced your name. Could you introduce yourself and just let us know how much time you think you'll need to present?
My name is Maddie Throneberry. I'm here on behalf of 10 Roads Express. When I'm giving an estimate of time, should I be including John's time as well, or am I just talking about my time?
Just yours. Yeah, just your time.
Okay, I would say maybe just an hour to be safe, but I promise to not try to take up an hour of your time.
Okay, no worries. And then Mr. Sharp, if you could take a microphone up here and introduce yourself, and just because they can't hear you online if you don't have a microphone.
Yes, my name is John Sharp, and I'm representing the Office of State Assessed Properties today in the 10 Roads Express appeal. I would estimate 30 minutes.
Mr. or Mrs. Chung, if you could introduce yourself, whoever's going to be speaking on your behalf, and then let us know how much time you think you need to present.
Shouldn't be very long. Shouldn't be very long. Oh. Can you hear me?
I can, yes. I can. What's your name?
Jesse Chung.
Okay, and how long do you think you'll need to present?
Hold on a minute. Let me put on the earphone.
Okay.
Okay. Okay, I can hear you. You asked me how long the presentation gonna be, right?
Yes, how long is just your presentation?
I think maybe half an hour, no more than 45 minutes.
Okay, thank you. Next, we have the Shelby County Assessor's Office. Shelby County, do you have a time frame for how long you think your reply will be? Sorry, and introduce yourself, Mr. Moore. I see you all the time.
Yes, Mr. Polk. My name is Elmer Moore III with the Shelby County Assessor's Office. I am joined by Mr. James Polk. We will need probably about 3 minutes.
Okay. And then finally, Ms. Plants, I see you're on the line. Introduce yourself and give us an estimation how long you think you'll need.
Excuse me, my name is Kelly Plants. I'm guessing maybe 45 minutes, half hour.
All right. And then Ms. Gass for the Jefferson County Assessor's Office, introduce yourself and let us know how long you think you'll need.
Susan Gass, Jefferson County Assessor's Office, and about 30 minutes.
Okay. With my estimation, I believe that puts us at about Mr. Chung as the least amount of time. So I just try to do that to help get the room empty, and so we kind of reduce the number of callers who have to be on. And so we'll go kind of in that order, and then I think that's followed by you, Ms. Plants, and then finally with 10 Roads Express. All right, with that said, I will pull up a copy of our administrative record and go from there. Just a moment.
Mr. Pope, let me pose this question to you. It's gonna be recorded, right?
It's currently recorded. We're currently
great.
being recorded. Yeah.
Okay. All the member of the commission gonna have a color copy of my report?
The only thing I have as a paper copy is a copy of the initial decision in order. I think I saw Mr. Russ raise his packet. I think he has a paper copy. If you would like me to present any portions of your written copy of your written argument, I'm happy to pull that up on the screen and I can screen share it with everyone. Those are good
Okay.
questions. I will say too, at this time too, I guess I will ask you if anyone else has any other questions. Please let me know. This is a good time for those questions. But yes, I can highlight portions of the record. I can go back and play parts of the audio recording from your prior hearing. I have an entire copy of the administrative record, and I'll read a copy of what was part of the administrative record prior to today as well, before each hearing.
I have on my
Okay.
iPad. I
And then
have
Mr. Prophet also has a digital copy of your written argument as well. Of everyone's materials, actually. All right, with that, I'll go ahead and get started. Our first, oops, that's not, excuse me, sorry, I had the wrong document pulled up. Our first case of today, that being Wednesday, is going to be Mr. Chung. I got your final administrative record. So a final administrative notice of administrative record was filed by me on February 9th, 2024, including the following items. A May 4th, 2023 certified technical record, followed by an April 20th, 2023 acknowledgement of appeal to the commission, followed by a July 6th notice regarding record of appeal hearing, August 21st, 2023, the notice of scheduling conference, a December 19th, 2023 notice of hearing before the commission, a January 10th, 2024 taxpayers argument. I believe that was an email that was submitted by Mr. Chung, and then a January 30th, 2024 taxpayers additional argument was filed in this case as well. I will note ahead of time, one of those items that I read off was a notice regarding the record of the appeal hearing. I will kind of get to that too in just a second. So on July 6th, 2023, I issued a notice regarding the record of appeal. So the matter, which is captioned as follows: Jesse Y. and Priscilla Chung as the appellant versus the Shelby County Assessor's Office as the appellee. This is APD case number 53.01-224072J. That's State Board of Equalization appeal or case number 136155. Parcel G0232ANC00018 for tax year 2021. Caption notice regarding record of appeal hearing. The above caption matter is pending before the Assessment Appeals Commission. Under Tennessee Code Annotated Section 67-5-1506, the Commission's review of this matter is limited to the existing administrative record. The existing administrative record is generally limited to the certified copy of the technical record and a copy of the audio recording of the November 9th, 2022 hearing before the administrative judge. Pursuant to Tennessee compilation of rules and regulation 0600-01-.11 subsection 3, quote, a record of the hearing of any appeal before an administrative judge will be made by digital recording. Any party may, at its own expense, procure a court reporter to record the oral proceedings or a written transcript of the digital recording, end quote. When no party arranges for a court reporter or the administrative judge records the hearing via digital recording device. As a normal course of business, staff or the State Board of Equalization will request or otherwise procure a copy of the audio recording from the administrative judge. However, as of today's date, that being the date of July 6, 2023, no audio recording has been filed with the Assessment Appeals Commission. As evidence in the attached affidavit, the administrative judge avers the relevant audio recording is unusable. As such, no audio recording of the hearing before the administrative judge is available. The parties are otherwise hereby notified of the missing audio recording and incomplete administrative record. If either party has a copy of the November 9th, 2022 hearing, you must file a copy with the Assessment Appeals Commission as soon as possible. You will note from the notice of administrative record, no copy of the audio recording was then filed on behalf of this appeal. So I will say out loud to everyone, to our commission members, to Mr. Chung, and to Shelby County Assessor's Office, no audio recording of the hearing before the administrative judge exists. There is an attached affidavit from the administrative judge in this case, that being Administrative Judge Jerome Cochran, who notes at some point after the conclusion of the hearing, but before issuance of his decision, he became aware that the digital recording of the audio file was not functioning correctly, and therefore the audio recording was not usable. That is from Administrative Judge, Administrative Admin Record, page 0054.5. With that said, I will still read a copy of the initial decision and order, since that is what is under review today. This is part of the administrative record. Let me see, the final administrative record, pages, I believe. It's part of the certified technical record. It's easier if you do that. It's on the certified technical record. That is the blue page number. Is going to start on page 34. It starts off with the State Department letter noting it's January 31st, 2023. Follows on the next page of in the matter with that same case caption that I read previously. Followed by order, statement of the case. The Shelby County Board of Equalization, hereinafter the local board, has valued the subject property for tax purposes as follows: a land value of $210,000, an improvement value of $454,300, for a total value of $664,300, and an assessment of $155,075. The taxpayer filed an appeal with the State Board of Equalization, hereinafter State Board, on September 20th, 2021. The assessor's office filed a counterclaim seeking an increase on the assessed value on October 21, 2021. The undersigned administrative judge conducted a telephonic hearing of this matter on November 9th, 2022. The appellants, Jesse Chung and Priscilla Chung, were represented by Jesse Chung at the hearing, hereinafter the taxpayers. The Shelby County Assessor of Property was represented by staff appraisers Elmer Moore and James Polk, hereinafter the assessor's office. Summary of evidence. The taxpayer, Jesse Chung and James Polk, testified at the hearing. The following exhibits were introduced. Exhibit 1, the assessor's office's valuation analysis. Findings of fact and conclusions of law. The subject property in this appeal consists of a house on approximately 1 acre at 9589 Colthurst Cove in Germantown, Tennessee. The taxpayers contended that the subject property should be valued at $570,000. The assessor's office requests that the local board decision of $664,300 for the subject property's valuation be affirmed. The basis of valuation, as set out in Tennessee Code Annotated Section 67-5-601 subsection A, is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11 subsection 1. At the hearing, the taxpayer raised the following issues to support his contentions that his proposed valuation for the subject property should be adopted. 1, the taxpayer's subject property's tax valuation increased by 27.5% since the last assessment, which was double the average of his surrounding neighbors. There was no basis for the increased valuation of the subject property. 3, the assessor's office's valuation analysis relied on unreliable comparable sales. He also notes at footnote 1, after the hearing, it was discovered that the digital recorder was not functioning properly and the hearing's recording was not usable. I'm going to pause at this time. Mr. Chung, did you have a question or some comment you needed to make while I read this out? Mr. Chung, did you have an issue we need to resolve? Are you able to hear me?
Hold on a minute.
Okay.
We lost the video. Hold on a second, please.
是我要 to get rid phone. I had to get rid of the phone. Oh,
See. Uh,
sorry. My phone rings.
Oh, no worries. We've all been there before. Are you able to, or are we back on track? Can I continue?
okay.
I heard an okay, so I'm going to continue reading out the order again. This was previously sent out to everyone via Microsoft OneDrive and email. Continuing on to the page 3 of 4, point 4, the property card contained an error with respect to the number of rooms in the subject property and an overvaluation of the tennis court.
Oh, you want me to respond to that?
No, I'm just reading the order. We're still not done.
Oh, yeah.
Based on a review of the testimony and evidence, the appraisal report provided by the assessor's office is compelling and appears to be a more accurate reflection of the value of the subject property. The taxpayers testified that the assessed value of their property had increased at a higher percentage than another nearby properties. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the Commission rejected such an argument in E.B. Kissel Jr., reasoning in pertinent part as follows. The rate of increase in the assessment of the subject property since the last reappraisal or even last year may be alarming, but it is not evidence that the value is wrong. It is conceivable that values may change dramatically for some properties, even over so short of time as a year. The assessor countered with properly adjusted comparable sales contained in their appraisal report. These sales established a range in value for the subject property of $492,400 to $863,948. This led to the assessor's office to recommend that the valuation of $664,300 by the local board of the subject property be affirmed. Further, the assessor's office's valuation of the tennis court is reasonable, and the error with respect to bedroom count on the tax card is harmless and does not affect the subject property valuation. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. The assessor's office's comparable sales approach supports the valuation of the local board. It is therefore ordered that the following values be adopted for tax year 2021. Land value $210,000, an improvement value of $454,300 for a total value of $664,300 and an assessment of $155,075. This order was entered on January 1st, 2023 by Administrative Judge Jerome Cochran. I will go ahead and note Judge Jerome Cochran is no longer with the Administrative Procedures Division or the state of Tennessee. And so if this were to be remanded, it would go back to an entirely new judge. The order concludes with a final page noting available remedies, including appeal to this body, which is why we are here today. That is the initial decision order. That is the order that is under review. That is what the commission is tasked with hearing from the parties about why you believe that order, as I read out, was decided correctly or was decided incorrectly, essentially, based on one of those 4 enumerated factors. With that, I will hand it over. Again, the procedure for today is Mr. Chung. I will ask you to go first. We will give an opportunity for the assessor's office to make a reply, and then you'll have an opportunity for any final comments. I generally ask the appellant to help navigate for the commission. If you could state out loud, Mr. Chung, explicitly what you are asking the commission to do today. And I say that by prefacing that the available options, as I read previously, are the commission may affirm that decision of the hearing examiner. The commission may reverse part of all or part of that decision, and they can remand it for further proceedings. So with that understanding, Mr. Chung, the floor is yours to make your initial argument of what you would like but if you could start with just identifying what you would like the commission to do today, and then you'll have the floor for any additional argument you would like to make. With that, Mr. Chung, I'm going to stop talking and the floor, we can see you on camera, so it is your opportunity.
you want me to ask the commission member what can they do for us?
I can answer that question. It's not really a time for questions right now, as much as the commission can do one of a few different things. They can affirm that decision that I just read out loud. They can remand the case back to an administrative judge for further proceedings, or they can reverse the decision. We are not finding a new value today. That is not part of the commission's role. The commission's role is to review that decision as I read out just now, and to hear argument from you as to why you believe that decision prejudiced your rights or was decided incorrectly for some reason. Those reasons either being it was in violation or did not follow the law, was made upon some sort of unlawful procedure, the decision was otherwise arbitrary or unsupported by evidence. So those are kind of the main factors that the commission is looking for. I usually just ask if you could identify what you are asking the commission to do, reverse the decision, remand the decision, kind of what you would like to happen today, and then otherwise continue with your argument about why you believe that decision was decided incorrectly.
Okay. Let me first begin to say that to everybody, it's good morning. And I want to express my sincere gratitude and appreciation of the commission to let me have the opportunity to present my case in an equitable manner. This is important for me to emphasize that I'm not a serial petitioner, nor do I oppose paying my fair share of taxes when warranted by the market condition in my neighborhood. My track record success in the past 3 appraisal cycle attests to this fact. This is with great concern that I address this issue at hand. The significant increase in valuation imposed on me is just not a matter of number, but a symptom of a larger problem that needs to be addressed. The lack of regard for the appealing process and outcomes by the Shelby County Assessor Office have left me with no choice to repeatedly defend my right to accept fair tax burden. The crux of the matter lies in the compounding effect of the overturned value from successful appeal being retained in the calculation model for subsequent appeal. This results in an unjustified and unsustainable increase that are not reflective of the true market condition. This is the elephant in the room that I'm here to address today. With that, let's turn to page 00071.
All right,
Table
give me 1 moment to get there. I'm almost there. It said 0071. I'm more than happy to highlight parts of that record. Let me just get there real quick. Our commission members, again, like yesterday, I'm going to highlight this on our screen. You're welcome to move around if you would like to see it. This was included in Mr. Chung's materials he submitted in advance of today. All right, Mr. Chung, is that the right page?
Oh, yeah, yeah. Thank you. It didn't show the title, right? Or my screen did. Oh, yeah. Okay, okay. This is a table showing my neighborhood. I've been living here for the last 30 years. And it shows the last two cycles of the appraisal. 2000 and 2021 tax year. The table shows that from the 2017 on the column 4, my property is fully valued even at 2007 and 17. And you can see the dollar per foot value is totally aligned with the rest of the neighbor. It is high at the number 4 position of the sixth neighbor. And then you see in the 2021, my dollar per foot value went from 116.8 to 149, right to the top of the pack. That's keynote number 1. The other thing is the percent including in dollar value over 2007 and 10 for a aggregate average for the rest of the neighbor is only went up 15.6% versus 27.5% for the subject property. The other one, I highlight in the bottom half, the 9680 neighbor and 9589, the subject property. You will see that the per dollar per foot rent is about the same at that time. And then in 2021, my property went up to 149 versus 133.5. And the value went from $60,000 more than my neighbor. My neighbor being a bigger house with 490 more square foot, has a higher value of $60,000. But in 2021, the value of my property even went higher than my neighbor, more than 60,000. So it points to me this increase is totally unjustified, a basis. With that, let me see. Let's turn to page 74 and 75. It's after a successive appeal in November 2017, the subject property will deal to $521,000 to from $585,000. I have strong reason to believe that Shelby County Assessor Office allowed the overturn the value of $585,000 to remain in the math formula for calculating the new valuation. When the new increase will compound with the overturned value, results in an exuberant and unjustified price. Fact be told, this is a persistent and insidious problem. It can be traced back to the past three appraisal cycle. Below, I can demonstrate in simple calculation that the above zero charges are indeed very troubling and need to be dealt with all seriousness and transparency. Okay, if I use the 1973 value of $521,000 times the good average increase, equal to $600,000 and $276. It's nowhere near the assessed value of $664 and $300. If I use the percent increase on my neighbor, it will result in 591 and $595. It's nowhere close to the assessed value. But if we look at using the $585, the overturned value, time the group average increase results in $676,000. It's a lot closer than the previous value of 520 cents. If we time that using 13.5 and you result in exactly the $664 and 300. So this is the evidence number one. And then if we use the give me a minute. If we calculate the other way, using the building value equal to property value minus land value minus both BY value. Okay, if we use the overturned value of $585,000, I will result an increase of 56.3% increase. And if I use the neighbor using the same number, their building value went up only 22.9%. If I use the $521,000 value plug into the same equation, I will result a number increase of 22.3%, which is aligned with my neighborhood increase. If I do with all my neighbors in the same way, it will result in the same result, maybe by 1 to 2% different. So that's the two way to get around to the truth behind the figure. This is the scheme employed by the Shelby County Assessor's Office, at least for the last 3 appraisal cycles. Thus, the logical appraisal value for the subject property would be no more than $591,000 and not the $664,300. I respectfully request the Shelby County Assessor to disclose the true value yield and the percent increase assigned to the calculate the 21-21 tax year appraisal on the subject fact. This will help to bring a speedy resolution of this appeal. In the
Anything else, Mr. Chung?
no, I have some more to go.
Okay.
On page 76 to 78, we show the difference between the subject property and the immediate neighbor of 9616 Cohort Road. I cite this in example.
Are these originally part
Because
of the
this-
administrative record?
Yeah. Yes.
Okay, Mr. Chung, what?
Okay. As you can see,
Continue. We've got the photos in front of us.
I say that again, please. Yes.
When you're ready.
Okay. I want to cite this example, which I use its percentage, because it shows that this house is much closer to my house inside, except this house is 490 square foot bigger. And they have the same stucco, synthetic stucco for the cladding material. The other thing, yes. You can see my neighbor have a decidedly more curved appeal and more amenity and feature. Also, I underlined the current state of the subject project. I'm not going into the detail in. I think the photograph should show the current state of my property. Is basically a fixer upper compared with all the comparable sale cited in the analysis report. When you consider the valuation, or also the analysis report, it's not just a academic exercise at arm's length. It should take into the consideration the actual condition of the property in question. because in the condition of any product, be it a previous owned car or previous owned house, or just produce in the grocery store, the condition of the property in question is very important. It's the deciding product. It's so go with the tenant's car issue. The tenant's car haven't been used in the past 10 years. And
Hey, Mr. Chung, I don't want to entirely cut you off. I just feel like we're getting down to talking about your contentions about the facts of the case. I mean, what part of the decision of the administrative judge? I'm we're trying to stay on the rails here about talking about the decision and kind of what your issue is with the decision. Not necessarily here to rehash all the evidence that was going through. So what? I guess at this point, I'll kind of just interrupt. Say, do our commission members have any questions at this time?
No, I don't have any questions at this time.
Yeah, hearing and seeing none. Mr. Russ, any questions?
The only question that I would have, do any of your neighbors have tennis court or swimming pool or anything else that might change?
All of them have swimming pool.
Thank you.
All right, Mr. Chung, again, I'm just going to reiterate, we're here to hear about what issues you have with the initial decision and order as decided by Administrative Judge Jerome Cochran. Any other comments before we let the assessor's office respond?
Yeah. You want me to respond?
Hold on a second, Mr. Russ.
Was the information that you just went through, was that available at the first hearing? Did the administrative law judge see this information? The calculations that you had done on your neighbor's property and increase from what the original amount was, the percentage, and that all this type of information on these pages that you just highlighted to us.
I guess
Yes, the administrative law judge did have that.
No,
All of this with.
no, I just want to clarify what he's asking for.
What I'm asking for?
Yes,
Mr. Chung, did you show these photos to the administrative judge?
yes,
Okay. Did you explain your calculations that you just reiterated to the commission? Did you explain that to the administrative judge, or did you calculate those after the hearing?
after the hearing.
I think that answers the commission members' questions. Thank you.
Thank you.
All right, Mr. Chung, I'm going to ask again, the initial decision and order, that document I read at the top of the hearing. Do you have any, before we go to the assessor's office for just for their reply, any final comments about issues about Judge Cochran's decision?
For me to answer?
If you have any other comment, now is the time.
Mr. Polk,
Yes.
you want me to address?
That question is to you. So yes, Mr. Chung, I'm talking to you, Mr. Chung. If you have any other comment about the decision of Judge Cochran's order, please let us know and please continue.
Okay. There's so many. I originally, in this hearing, I don't want to go into Judge Cochran's performance or non-performance. I want to just to figure speak for the truth and not the person, somebody performance or behavior. But if you ask me to comment on judge decision, I don't agree with this decision 100%. Judge Cochran, from the very beginning, in the discovery period, he shown to be indifferent, disinterest, and he looked like a bystander than the judge. If you look back on all the email in the technical report, you will show that he seemed like an absentee judge. He seemed to be on the lake fishing than performing a job of a judge. On his decision, obviously, he didn't get the whole picture of the hearing because he already make up his mind. And the case he cited in his report have no relevancy to my case because I looked at the original report. He called a dramatic or alarming increase is 13%. And the subject property owner cited only one sample. There's no detail describing why the increase is warranted. So the lack of detail and a lack of sample doesn't constitute a good example of tax case. Plus, Judge Cochran stated in a sworn affidavit, he claimed after the hearing, he find that recording is malfunction.
Yes, Mr. Chung, we've well established that the audio recording malfunctioned, that there is not an audio recording of your hearing. In purpose of time, I've already read that. It's an explicit part of the record. So I'm going to move past that. I think at this time, Mr. Chung, I'm just going to ask the Shelby County Assessor's Office, pivot over to the Shelby County Assessor's Office. Shelby County, do you have a reply? I know you said you only needed like 3 minutes. So Mr. Moore, I'll hand it over to you for a reply.
Yes, Mr. Pope. At the administrative hearing, Mr. Chung did not present any comparable sales in his neighborhood. He did talk about the condition. He did not present the evidence about value increases, although he did talk about it a lot. That is irrelevant to reappraisal values. The assessor's appraiser, Mr. James Polk, presented a valuation report that had 6 comparable sales in Mr. Chung's immediate area, which is a part of the administrative record. Those comps were properly adjusted and supported a value of about $728,500. When Mr. Chung brought up some of the condition issues, we requested that the local board's value of $664,300 be upheld. This $64,000 difference should account for any deferred maintenance that Mr. Chung is suffering from. So we don't think that the judge made any procedural errors. We would ask the commission to uphold Judge Cochran's decision. Thank you.
Any questions from our commission members? Seeing and Mr.
I do not have any. Mr. Bowles or Mr. Prophet, do either of y'all have?
I just had one, looking at the exterior of the home versus the homes around, that was the comparables. It looked like there was some corner work, a cabinet mill on the exterior that looked a little bit different. Are the calls on the exterior of the home basically the same, or?
Yeah, Mr. Prophet, I think you're getting into a little factual issue there you're asking about the specific
card should be in there, but I didn't know if that was on their appraisal, if it was the same, but
the condition or
the exterior, it's in the.
Yeah, I know their appraisal report, their evaluation.
Their appraisal, the county's appraisal report. And, but that's the thing I could see that wondering on how they were, if it's an issue.
Yeah, that's a testimony of the appraiser, yeah.
That's not, just draw the question.
Mr. Bowles, any questions?
I have a question.
No. Hold on a second, Mr. Chung. Okay.
I do not have any questions.
All right. We've heard from the Shelby County Assessor's Office. Mr. Chung, is your opportunity for any final comments about your appeal and what you were asking the commission to do again today?
I want to the commission to consider the data, the calculation to show that what is the reasonable result. I think it's not a number. Let's look at the elephant in the room. The mother of all this issue, which is Shelby County up to today. They don't want to address that question. And as for what I did not put forth in the November 9 hearing, is because the Shelby County falsely accused me and no shows in the Shelby County Equalization Board.
Mr. Chung, I'm just gonna kind of refocus. And you're getting into things having to do with Shelby County and County Board of Equalization hearing and things like that. We're really just here to review the decision of the administrative judge. And so I read a copy verbatim of that decision. We're really here only to hear arguments about why you believe that decision that I read was incorrectly decided. We're not here. We are not here. Let me repeat. We are not here today to bring up and relitigate factual contentions that were made at the administrative judge. That is not the purpose of today's hearing. We are here to review that decision as it was made. You know, to a certain extent, I understand that you're going to talk about what happened at the hearing, and we can look at parts of the record for your arguments about why you believe that decision was incorrectly decided. But we're at the end of the day, we really are here to review that decision. We have a bunch of other appeals to get through today as well. I did ask you how long you think you need to present. I think you've had ample time for over 30 minutes. So I'm really going to ask you to try to get to your final points here about what issues you had with the decision of the administrative judge. I will read it again if you want me to. But that's really what we're here today, and we really have other appeals we do need to get to. I don't want to rush you, but what are your arguments about that decision of Judge Cochran? If you give us those final comments, I'll probably give you another maybe 15 minutes, and then we really do have to get on to some of our other appeals.
Well, since he doesn't have the recording to review the whole hearing.
Mr. Chung, I'm gonna cut you off then. We've already well established. I put it in the record. I filed a notice. I addressed it at the beginning of this call. The audio recording does not exist. I will tell the commissions for you, commission members, if you find that the lack of an audio recording, the failure to have that preserved is a abuse of discretion or somehow unsupports that decision, you have full discretion to remand it back for a new hearing. I believe that addresses your concern, Mr. Chung. What other comments do you have?
Well, I want the commission to overturn the judge's decision.
All right, thank you. With that, we'll otherwise enter deliberations. At this time, Mr. Chung, there's no more communications between yourself and the commission members. Commission members, a couple of questions to guide your deliberations. Remember that Mr. Russ is your presiding member. So generally we are looking for, did the administrative judge misapply the law cited in this case, or did they otherwise misapply the principles of appraisal in the case as decided? Was the judge outside of his scope of authority? Was the decision supported by substantial and material evidence? Again, if you find that lack of an audio recording as noticed in the record is a procedural error, as such needs to be remanded for a new hearing to have the audio recording, you are free to do so. If you find that the rights have been prejudiced, of the petitioner have been prejudiced. With that, Mr. Russ, I'll hand it over for you for deliberations.
Thank you. The administrative judge and the record show no comparable sales provided by the property owner to support the property owner's contention that the county board's decision ought to be reversed. Despite differences in the percentage of an increase in what the assessor has valued the property for between one appraisal term and another, has been adjudicated over and over and over again. So that, in a real short answer, I don't believe that the property owner has provided any substantial support or evidence to support his position. And I'll ask Prophet.
Just overlooking the paperwork from the hearing, that the taxpayer, the plaintiff, had submitted. On the first exhibit that he asked us to look at with his calculations, it shows that county board in 2017, I think, had lowered his values. Just roughly looking at it quickly, it looks like somewhere around 11%. Well, then we get to now, and there's an increase. It didn't look like whatever happened in 2017 was a permanent record on their card, probably when we get to the point we are now. Apparently the county went back to some prior idea of the value of the house or the grading of the house. That's where I was thinking of, if it could explain a difference in the grading of the house, which may or may not be part of the record. So, but it appears it would be. That's just kind of where I was looking. And then that would cause a much larger increase because the county board lowered it in 2017. Then all of a sudden we get to revalue the house, which makes it kind of look like a higher percentage. I just really don't see any evidence here to overturn the judge's decision, because the audio recording's one thing, but we have a case file here, what was submitted, and that's what should have been reviewed, and it does appear that it was reviewed and reflected in the order. So I think we should uphold the judge's decision, and I'll defer to Mr. Bowles.
Mr. Bowles?
I think the taxpayer is probably used.
Mr. Bowles, I cannot hear you. You have to.
Can you?
Yes, sir.
Okay, I think the taxpayer probably has used a model that's not utilized in the appraisal industry. So everything he's presented can be changed by another mathematical model. So I'll have to support the judge in his decision.
Okay, do we have a motion that the decision of the administrative law judge be affirmed?
I make a motion to affirm the administrative law judge
Okay,
decision.
I'll second that. All those in favor, say aye.
Aye.
Any opposed?
Ayes carry. The motion carries. The decision of the administrative law judge is affirmed. We will issue a written order memorializing that decision within the next 90 days, and that will otherwise be the final action. I'll explain further remedies, Mr. Chung. If you'd like to appeal to Chancery Court, you may. How to do so will be included in the order in the final pages. That concludes our business for our first appeal today, Mr. Chung versus the Shelby County Assessor's Office. Both of you are free to leave or otherwise stay and observe. It is an open meeting. This time I will ask our commission members, do any of you need a break before we continue? Yeah, okay, we're gonna take a 5-minute break. I'm gonna leave the call open. We'll come back right at 10:25, if that's okay. Just because we got some other appeals we're trying to get through this morning. Feel free to, I'll stay on the line if anyone has any other questions. Commission members, we got about a 5-minute break. I see our commission is back, so we can go ahead and get started. We're still actively being recorded, so we'll, like I said, our next appeal is with you, Miss Plants, and you, Miss Gas, for our next appeal. Let me pull all that up. I should have done that before now. I do still got to read a copy of that initial decision in order. I know there was an order on the reconsideration request as well. Let me get it. This one. So the initial decision order is predominantly what's being reviewed, but the order to deny reconsideration is also conceivably reviewable. I will kind of paraphrase that one, but if we're ready to get started, I see our commission members are all here. Okay, we're good. Our next appeal this morning is going to be in regards to Kelly Plants versus the Jefferson County Assessor's Office. That is SBOE appeal number 124131. For tax year 2019, parcel 076B, group B, parcel 47. The initial decision order reads as follows. Statement of the case. The Jefferson County Board of Equalization, hereinafter the local board, has valued the subject property for tax purposes as follows: a land value of $176,000, an improvement value of $681,400, for a total value of $857,400, and an assessment of $214,350. The taxpayer filed an appeal with the State Board of Equalization hereinafter State Board on July 24th, 2019. The undersigned administrative judge conducted a hearing of this matter on December 4th, 2019 in Dandridge, Jefferson County, Tennessee. The appellant, Kelly Plants, represented herself at the hearing, hereinafter the taxpayers. The Jefferson County Assessor of Property was represented by the Assessor of Property, Susan Gass, hereinafter the Assessor's Office. Summary of evidence: the testimony of the parties in the following exhibits. Exhibit 1, the taxpayer's document summarizing previous values of the subject property. Exhibit 2, the taxpayer's document summarizing subject property value ranges. Exhibit 3, the taxpayer's comparable sales. Exhibit 4, the taxpayer's statistical market analysis. Exhibit 5, photo of the subject property. Exhibit 6, previous initial decision in order. Exhibit 7, real estate assessment data of nearby properties. Exhibit 8, the Assessor's Office packet of comparable sales and analysis. Exhibit 9, tax cards and photos of the Assessor's Office's comparable sales. And Exhibit 10, home sales information of nearby properties. Findings of fact and conclusions of law: the subject property in this appeal consists of approximately 1 acre with a house at 2179 Majestic Circle in Dandridge, Tennessee, 37725. The house of the subject property was built in 2005 and purchased by the taxpayer in 2014. The taxpayer contended that the subject property should be valued at $730,000. The Assessor's Office contended local board's valuation of $857,400 for the subject property should be affirmed. The basis of valuation set out in Tennessee Code annotated section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. That's the State Board rule. At the hearing, the taxpayer testified that the subject property was purchased from a bank in 2014 for $675,000. After several years of the property being advertised for sale by the bank, who received it through a foreclosure. The taxpayer further testified that the subject property is a lakefront home. However, there are significant rocks on the shore that limit lake access, and there is no dock. The taxpayer would also testify that the market does not support the Assessor's Office valuation and that the percentage increase from the previous year seems high. She also stated that the Assessor's Office has failed to take into account the zoning issues with the subject property. The taxpayer would also state that adjoining property values did not increase as much, and that she has made no changes to her property, and despite this, her property had the largest value increase in the subdivision. The taxpayer concluded by testifying that the stucco structure of her property hurts its value, and that the housing market in the county is relatively stable, and that she could not sell her property for the appraised value. The Assessor's Office testified that the subject property was undervalued. The assessors further testified that the boat docks are not taken into account in assessment, and the rocks on the lakeshore were not considered into the current assessment of the subject property. The Assessor's Office introduced comparable sales that the taxpayer claims were not good due to their inaccuracies. The taxpayer testified that the value of his property had increased by a larger percentage than other nearby properties since the previous assessment. However, the Assessment Appeals Commission has repeatedly rejected arguments based on the amount by which an appraisal has increased as a consequence of reappraisal. For example, the Commission rejected such an argument in E.B. Kissel, reasoning in pertinent part. The rate of increase in assessment of the subject property since the last reappraisal, or even last year, may be alarming, but is not evidence that the value is wrong. It is conceivable that values may change dramatically for some properties even over so short of time as a year. The taxpayer's use of sale prices of nearby properties is not a reliable indicator of the property values, as the values she relies on fail to make adjustments in values when compared to the subject property. Factors such as age, time of sale, building materials, etc. were not taken into account in the comparable sales listed in his sales chart. So these comparable sales are not a reliable indicator of what the home value are compared to subject property. The Assessment Appeals Commission has said that for comparable sales to be relevant, they must be properly adjusted. In E.B. Kissel, the commission said the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use a sale as an indicator of value. The assessor's office's properly adjusted comparable sales were more reliable than the comparable sales presented by the taxpayer. This price, based on square footage, established a range in value for the subject property of $129.53 to $165.70, which led the assessor's office to recommend a value per square footage of $131.38 for the property, which is the lower of the price range based on the assessor's office's analysis. Respectfully, the evidence introduced by the assessor's office comparable sales analysis supports the value determined by the assessor's office and the local board. Ordered is therefore ordered that the following values be adopted for tax year 2019. That is a land value of $176,000. An improvement value of $681,400, a total value of $857,400 for an assessment of $214,350 is the assessment. That order was entered on February 10th, 2020. I then need to make sure I go through parts. That's the order for review. It concludes with applicable remedies, including appeal to this body, which is why we are here today. I forgot to read this in the beginning, but it doesn't really quite matter. That we had the notice of administrative record that I sent out on February 9th. This did not have that certified technical record we're maybe more used to seeing from Administrative Procedures Division. This case was before they instituted that, the administrative procedures. So I'm going to read through the administrative record documents that I had for this case. We had the July 24th, 2019 County Board decision. We then had the October 4th, 2019 notice of hearing before the administrative judge, followed by a December 4th, 2019 hearing exhibits. We then had the February 10th, 2020 initial decision and order that I just read. We had the February 25th petition for reconsideration. At the same time, I think we had an appeal, because then in the following document is a February 26th acknowledgement of appeal to the commission. We have the February 26th taxpayer argument Excel. We have the February 26th taxpayer argument Excel 2, and then we have the February 26th taxpayer argument item 2. We had the April 30th, 2020 notice of hearing before the commission. We then had an August 20th, 2020 order of continuance, followed by an August 21, 2020 reconsideration granted. We had a December 27th notice of hearing before an administrative judge. We had the October 27th reconsideration hearing exhibit 1. We had the October 27th, 2021 reconsideration hearing exhibit 2. We had a December 3rd, 2021 order denying reconsideration, followed by a December 19th, 2023 notice of hearing before the commission, a February 1st, 2024 request to continue, and then a February 5th, 2024 order denying the continuance. Total page count of 160 pages, I believe, of actual record, with the 2 introductory pages. Those page numbers are marked in that red font on the bottom of the administrative record. For all the parties today, if you want me to pull up or share any documents from the administrative record, I'm happy to do so. Using that red page number is going to be the most helpful thing to make sure we do it kind of in a timely fashion. Happy to do that. That is the administrative record. That is the initial decision under review. As a reminder, we're going to follow that standard procedure. We'll start with Ms. Plants, and then we'll have the assessor's office opportunity for a response, and then Ms. Plants will have an opportunity for final comment. I believe we introduced the parties at the head of the hearings today, but I'll head it over to Ms. Plants. Ms. Plants, if you want to go ahead and introduce yourself again. And like with our last case, I usually just ask if you could identify what you are asking the commission to do today. It kind of helps the commission and us kind of understand where we're headed and what you are asking for. But then your other is free to kind of, the floor is yours, and enter your arguments about today's hearing. Sorry, I forgot if we need to go over the order denying reconsideration, I'm happy to pull that up as well. if you would like to, if you want to bring up any of that order as well. At that point, I'm gonna stop talking, and Ms. Plants, the floor is yours.
Thank you so much. I appreciate the opportunity to speak to the commission today. A little bit of background about myself. I'm a certified public accountant. I've been in public accounting since 1993. I hold 4 CPA licenses in various states. I also work in the area of mergers and acquisitions. So although I am not a real estate appraiser, I am familiar with valuation properties and general concepts. This is on the verbal record, but just to reiterate a little bit of background in my case here. I did buy this house in 2014. It had been on the market for many years and then it ultimately went into foreclosure. It sold on the courthouse steps for $515,000, also in 2014, $515,000. Had I known that was going to the courthouse steps, I would have participated in that auction. I did buy it in a bid process with 3 other bidders, and I was the successful highest bidder, and I purchased the home in 2014. I had a previous appeal process because I received my in property tax increase for 15 and 16. And my property assessment went up to $850,000, approximately $850. So I appealed that in front of Judge Aaron, and I also, as part of that process, to date, I've actually commissioned 4 valuations on this property. 4. The first valuation, I actually struggled to get to 675 because of the earlier foreclosure. There's some reasons for the value of my property being a little less than what you might expect. Part of it is the house itself. It is a larger footprint house. It's comprised of stucco, which is very undesirable in this location. My neighbors refer to my house affectionately, I like to say, as the stucco house. Our neighborhood, they like to have brick homes in the neighborhood, and historically that's pretty much what the association has tried to navigate towards as people are building houses. My builder built the Florida house and had a lot of difficulty selling it. So I appealed my valuation and one that was successful in that, in getting it back to what I deemed is a reasonable increase from where I had purchased the property in 14, which, based on the average increase in the county, having no prior improvements done or no catalyst for a large increase, I wasn't simply arguing under the Kissel case that there was no possible way that my house could have went up that much. I was arguing there was no catalyst for an increase relative to market values, market conditions, and what I had done to the house. And it was put into the permanent record that my house was valued at $690 and $675 for 2015 and 2016. This is also in the recording. I give you this to just set the stage for where we ended up to now. When I received my assessment notice in 2019, it had been increased to $852, which surprised me because, again, I had made no improvements to the home, and the average market value, I believe, in the county had increased 4 to 6%. That's based on the national statistics, and that's known data. I called the assessor's office, which was step 1 when you receive your initial assessment, to have what I had hoped to have, a professional discussion around why the value increased. And I think it's important to the integrity of this process that a taxpayer should be able to have professional discussions and bring forth professionals to help support their value without fear of reputation damage, retribution, or other slander. That's important to this process. And I don't necessarily feel throughout this process I've been afforded that. So I called the assessor and I asked to speak through why my value went up to $852 from $690. And I wanted to understand her rationale for that, given that I had had no improvements. The average in the county was 4 to 6%. The average in my neighborhood, which would be my close neighbors, was only about 7% on average. The result of that phone call is she got upset and she increased it $5,000 on the spot with no basis. Excuse me, I've contracted a sore throat from a funeral. So that was a little frustrating to say the least. So I appealed the process. Because I had already had to come out of pocket and commission 3 valuations, the initial hearing I went to, I felt like I could support it myself with my knowledge as a CPA based on the market conditions, based on, if you look at exhibit 005, that shows the record of all the other houses in my subdivision and where they stand in terms of value. Now, if you notice, my house is highlighted in that as the largest.
You give me
I'm
that
sorry.
page one more time? I
I'm
apologize.
sorry,
I'm
you
so
went to
sorry.
the wrong page. It says plants and min record 005 is what I'm looking at, and 004. keep
Sorry,
fl-
no, I just was trying to get there.
Yeah, sorry. I know I've got paper
3,
all over the
4,
place here.
5. Okay.
Yeah, so if you go back
Excel.
to, if you go back to 4, please, maybe for a second. Okay, yes. So this is a listing, and again, this isn't necessarily an indication of value. However, it does show what the average of the home prices based on inflationary measures, with, again, absent any improvements in my home, which I have had none. This would guide us as to what you would expect market conditions that would be. So as you go through these homes, some of them have no increase, some of them, the larger increases are typically construction differences. But my home, of all of these homes in the subdivision, had the largest increase of anybody. Which, just taking a step back, that doesn't make sense unless the appraiser, the assessor is trying to completely disregard the stated fair market value in 15 and 16. There would be no catalyst for my house to jump 24 to 26% in that short period of time. Again, with no improvements whatsoever and basic market conditions, which is a willing buyer and willing seller. You can't support that. So that was just sort of step 1 in this process for me, that I did not think this was a fair assessment. And for the integrity of this process, it needs to be fair to all taxpayers. So I appealed I appealed to the commission. I'm sorry, I appealed this process and I went before Judge Cochran. We can flip to um, 0021, I think. This just for the record, as you look at that just goes through the subject homes in my immediate neighborhood and their percentage increases. One thing about this area, unlike Nashville perhaps, where there's a lot of industries, there's a lot of high value homes, there's a lot of job opportunities. Dandridge is a small town. Knoxville is the closest large town. So, my home being worth $740,000, that is a high value home for this area. It honestly is. It's 400% over the average in this area. It is. So as a result of that, these homes in 2019 and prior tended to spend a little bit more time on the market. Meaning that they basically, if they went for sale, they occasionally sat for longer than your average home. Especially my home would potentially do that if I put it on the market because it has some detractors. As I mentioned, the stucco is a significant issue with my home, and that was a big issue in trying to sell it originally, and which potentially drove it into foreclosure because there was no buyers for my home. It's also a 3-bedroom home, which usually if you have a larger home, you tend to want at least 4 bedrooms. Mine's a 3-bedroom home. So as part of this process, when I went before Judge Cochran at first, I did not feel I needed to have a second valuation or third, I'm sorry, this would be the fourth valuation done on the home. I'd had 2 for the first hearing and successfully won that. And I had 1 for my original loan. And then as going into this, I thought basically looking at having no improvements, the market conditions in terms of actual inflation and willing buyer and seller, what the prices of homes had went up. I did not feel I needed to commission yet another valuation. The first judgment basically said that I really did need to basically have more objective evidence. So I went back to one of the appraisers that I had got the original, I think the third valuation for, and asked if she could provide me another one. She was actually retiring, so she recommended Creighton Cross to do the valuation for me. I did not know him before placing that phone call. He came recommended from another peer, so I thought that was a good fact. And so I reached out to him and I asked him if he could give me a valuation, and he did. I talked to him about what I thought the value would be based on simply looking at percentage increases and having no prior improvements on my home. That would have basically yielded a value of 720 to 730. That's taken the 690 times basically 6 or 7%, which would have been the market forces in action in 2019. And I also gave him the schedule of market values. Now,
Ms. Plans, sorry, is this part of the,
this is part of the
I'm just trying to follow.
This is part of the record.
Well, do you have
I apologize for the lengthiness. I will try to shorten the story. I'm trying to build to where I do feel like this Judge Cochran did not weigh all of the evidence properly in his decision, although albeit probably not intentional, is unsupported by the weight of the evidence that I did provide. And he's focusing solely on an argument under the Kissel case, which is not what I'm arguing at all. I'm not saying it's implausible that my house could go up in that period of time. I'm saying, given the fact that I've made no improvements, certain houses could go up. Mine did not. Mine has some factors that would not make it reasonable that that would go up. But also, as we go into, Ms. Gass brought to the table this guideline, which is not a valuation. So I did commission a valuation. I brought that with me to Judge Cochran's hearing. I presented it. I did not bring my appraiser. Honestly, the reason I did not bring my appraiser is because I felt that, again, since this was the fourth valuation I've had on the home, that's expensive. And I did not feel that it was equitable that I would have to pay for his time to come when I could go over the appraisal. And I thought it was very clearly laid out within the appraisal, and it was not necessary for him to come and support his appraisal. I felt it was very clear. And I think if the board or the commission looks at the appraisal, they'll see that it's extremely clear. This is also on the record. As we look to what Ms. Gass put as her comparables, which are different than my appraiser's comparables, and that is on 0021, please. Sorry, I'm going to get that out of my notebook so I can see it. Oh, okay. My home is the first home here. Mrs. Gass, her view of the value is she's purely looking at it from a square footage perspective, and she's trying to basically back into what the value would be based on square footage. Now, as I've already mentioned, my home is large, a large home, and you cannot simply determine value by taking an average square footage of comparables and multiplying it by the square foot, because there is a law of diminishing returns. If you have the largest pink house in the neighborhood, you are not going to necessarily be worth twice as much as another home in the neighborhood. So you can't simply try to do an analysis, which is not a valuation, and come up with a square footage and multiply it by the square footage of my home and say that's the value. That will lead to a skewed increase in value. And it did. the other issue that I have, if you look at the comparables, I honestly, again, I don't think Judge Cochran did this necessarily intentional, but as he references in his decision, my appraiser was not there, so he lessened the weight of my valuation. And I honestly think he did not properly read the valuation. Again, I don't think that was intentional or egregious, but I don't think he factored in points that were clearly made in my valuation. For instance, he asked why there were not comparative sales close to the subject property. All of the homes within my valuation are within 4 miles. That's extremely close to my property. They're not any of them out of county or even more than 5 miles away. And as the crow flies in this area, some of them were even closer. They're also very similar to my home in terms of original value and sort of, if you look at market conditions, they're very close to my home. And I think that they are very similar to my home, and he thinks they're similar to my home. If you look at the comparables that Ms. Gass is trying to pull, a minimum level of due diligence around these, and I argued this in the original recording, would quickly find that these are not comparable homes to my home for the most part. If we look at the Fiddle and Fish Cove home, that is a home called, it's based on 432 Trotline. That's in the materials as well. When that home was for sale and sold for $850,000, the highlights of the real estate ad said it was nestled in 5 acres. Nestled in 5 acres, 400 feet of shoreline on the main channel. That's a resort. That's not my home. That's not comparable to my home. And the other thing that I clearly pointed out multiple times in the recording is my home is on an inside channel. What that means is I do not have year-round water access, and that significantly devalues a lake home. I think the comments were a little bit confused when I said that I have rocks and I can't have a dock. I'm not suggesting that rocks and a dock go to the value of the home. I am suggesting, however, if you cannot dock a boat there and you cannot have easy flat water access, it does make your home not as comparable to a main channel home that somebody would describe as nestled in 5 acres and 400 feet of shoreline. I think I have 70 feet of shoreline. That's not necessarily pure flat shoreline. So the Trotline home is a completely different class of home. Now, you wouldn't know this by looking at this, and that's where I feel like Judge Cochran may have accidentally looked at these and taken these too much at face value without doing any level of due diligence to understand that these homes were far superior to mine. The White Oak home, again, that is a full brick home. It's listed as 5.7 acres. Now, some of these acres in both of these homes are possibly underwater, but they do have more usable acreage. And the other one is described in the listing as 5 acres of rolling woodlands. The Bridgeview home is also a main channel home. And again, main channel homes are naturally worth more than a cove home with seasonal water. All of these 3 were listed as homes that had round-the-clock water. There are some adjustments that were made, as I see Ms. Gass made a $25,000 positive adjustment to the Lake Cove home, but that doesn't discount the fact that these are far superior homes to my home. And my appraiser considered these homes because the total sales of homes in our area in this sort of this bracket of price, they're not that many. So it is difficult to get comparable homes, but you do have to take a step back and see, are these really comparable? And as I argued originally, these are not comparable homes to mine. And even if they are comparable, you cannot just simply, in coming up with a value of a home, take a pure square footage. My house is a U-shaped ranch. So taking a pure square footage basically is valuing the top square footage with the same as the basement, which is not appropriate to do. This is not a valuation. So the Breezy Point home, again, is 3.6 acres. That's actually on a point with a pure panoramic view, a very, very unique home and very walkable to the water. My home is significantly sloped, so it is not comparable to these homes. So while I think if I was on the assessor side, I might argue that these homes are comparable to mine, they're really not. And I argued that originally. Now, again, if I had had my assessor present, I think Judge Cochran felt that would have been a stronger view, but I don't think that was necessary to argue this point at all. I think if you were doing basic due diligence on this, you can simply look at these sold recently in 18. You can pull up the ads for it and say these didn't apply. And I argued that you cannot say a house with 5 acres or Finland Cove is described as a masterpiece in technology. A masterpiece in technology is how that is described in the listing. That is not comparable to my home that's had no updates since 2004. We go to Mr. Cross's valuation. Again, I did not have him come and present. In hindsight, that may have been helpful, but I do think.
Sorry,
Oh, I'm sorry. Can you need the page?
I just, do you have a page number? Sorry, yeah.
I'm
so
sorry.
didn't
I'm
wanna-
sorry. Let me get there. Uh, 0106. So I'm bypassing, but they're in there for your review and consideration. The adjustments, Ms. Gass argued that she made adjustments to, oh, I'm sorry, mine says 0106, sorry. There we go.
This is the appraisal report from
Yes, sir.
Mr.
Yes, Your Honor.
Creighton. That was, yeah.
Yes, yes.
So you had this appraisal in the record.
I did, yes. And so, sorry, I had Mr. Creighton, Mr. Cross do an appraisal for me, and he appraised the home. He visited the home, he did a walkthrough, he took pictures of the home. He did a market analysis of the home. He did a scatter plot. He commented on the value of diminishing returns. He commented on the sales of the higher end homes and how it's not appropriate to necessarily take a pure square footage and multiplying it by a larger footprint home. Obviously, a larger footprint home is more expensive, but it doesn't mean it's dollar for dollar double what your neighbors might be. He did pick the appraisals. He's made adjustments here. These are all sold in 18, which I was a little confused. And again, in the order for denial of return redetermination, there's the comment that I failed to present properties that are close to me, but these are all within 4 miles. And in fact, some of these are on the same street that the assessor used. So I don't know why that comment was made. 4 miles is well within the county and well within range.
I just want to, sorry, I hate to interrupt. I just want to make sure we're like, just for framework too, for everyone. There was this order denying reconsideration issued by Jerome Cochran much later on December 2021. It was in the administrative record. I didn't read part of this as well. It is technically part of the consideration for today's hearing. And so if we need to go through that, we can, but I just wanted to make sure clear what there was the initial decision and order. And then we had much later the order denying reconsideration in 2021. So here we are. Sorry, Ms. Plants. And I should pick up where you left off. You were talking about you were referencing this order, the order denying reconsideration, where
Yes.
Judge Cochran talked about something. Sorry, keep going.
No, so basically, this order was issued after, the original course. I said I didn't think I needed yet a fourth evaluation of my home, formal. As a taxpayer, I have to pay for that. They're not cheap. I also didn't think it was necessary because I felt like looking at just basic objective evidence of having no improvements made to my home, having the value established under law of 690, and that there wasn't a catalyst for a large market increase in our area in 19, I did not feel I needed evaluation. However, when I went to the hearing, I was dinged, if you will, for not having one. So I asked to have the opportunity to go get one, which I was granted, and I did. I went and commissioned a valuation from Creighton Cross, who provided me the valuation. When I met with him and provided him some of the data that I had told him that I expected, based on market conditions and no improvements, that my value would land around 720 to 730. I'm allowed to have those conversations with him. He did not do this valuation on a contingent basis. He did this valuation on a fair arm's length payment. And he has no interest in what my value is. And I've only spoken to him once since then. So I did not invite him, although he offered to come to the hearing, simply because of, honestly, a payment issue that I thought I don't need to do that. I'm a CPA. I'm familiar with the process, having went through and having 3 other appraisals, which is the only reason I didn't have him come. And I felt like I addressed Judge Cochran's questions, but I feel like when we stepped away, he did not put enough weight on Creighton's appraisal simply because he did not attend the hearing. And I honestly don't think that's appropriate. It doesn't become hearsay simply because he doesn't attend the hearing. It was a qualified appraisal. And I also think he did address some of the questions that came out in this order later. They're clearly addressed in the appraisal as to why we picked those subject properties. And the dates on them are not far out. You know, the reassessment date is 1/19. Those are all sold in 18. The assessor's properties are also sold in 18. So I didn't quite understand why there was a time issue there. I do think that, I apologize, my throat's super dry. I do think that I have put forth enough evidence to support my value. I think the market conditions support my value from the increase in 2015 and 16 up to 2018 and 19. I feel as though Judge Cochran, maybe not intentionally, but overly discounted the weight of my evidence because I did not bring the appraiser. And I feel like looking at this from an objective and evaluation principle perspective, I've proven beyond a reasonable doubt that I have done all the due diligence that I would need to do to come up with the value of what I put in to my request. What I'd like to come out of this hearing is to either have this judgment reversed or to have it thrown back so that if there is really an issue, my appraiser has said that he will happily come and sit and go over why he picked those. He has no issue with that. I invited him to this hearing, but I originally, and I apologize for that, I did not realize that that would be deemed new testimony, but I was quickly corrected on that. So I understand that that would be new testimony, but I don't think it would change. I think that it would further support why we did the values that we put in here. The other thing that's important that I think makes this, well, I'll bring this up. I just, again, I think that I have provided more than enough evidence to support the value that I put forth. And I think the assessor is being a little aggressive in her methodologies and how she has come up with the value. I think that she is reverting a little bit back to being a little bit bruised on the fact that Judge Aaron did not rule in her favor before. And I think given the aggression that's been put towards me when I initially called and some of the steps that have been taken since then, I think would illustrate that better as well. That's beyond the scope of this hearing. But I do think that you can objectively, as a commission, look at all of the evidence that I put forth, all of the market conditions, the fact that I have not made any improvements, and the fact that I did commission yet a 4th valuation on this, that does support the value of my home. I think I'm going to rest my case in the interest of time because I know you're all tired and I don't think I need to beat it anymore.
Well, and you'll have a final opportunity to comment too.
Thank
At
you.
this time, I usually just kick it to our commission members to see what questions you have. I just want to clarify too the reconsideration order. I'm going to read through that just because I know it's been brought up kind kind of explain with the order to deny reconsideration. So the order to deny reconsideration, like I said, was issued December 3rd, 2021. On February 10th, 2020, initial decision order was issued. Above style case, the appellant Kelly Plants filed a motion for reconsideration of the initial decision order, and a hearing was held on her motion on October 27th, 2021 at the Jefferson County Courthouse. Kelly Plants, the taxpayer, testified on her own behalf at the hearing, and the assessor property, Susan Gass, also testified. The issues raised on the motion are that sales compatibility analysis of county properties and an appraisal by a licensed appraiser would demonstrate the value analysis performed by the assessor's office is not accurate. At the hearing, the taxpayer testified that the percentage increase in the subject property is not supported by the market and is a greater increase than properties near the subject property, and that no improvements were made to the subject property since the previous tax year. The taxpayer introduced an appraisal performed by Creighton Cross of Knoxville, Tennessee, Exhibit 1, and a chart of property valuation increases, Exhibit 2. The assessor's office has stood on her prior valuation analysis and added in testimony that the comparative sales relied on by the taxpayer's appraisers were not properties located in the subject property subdivision, and that no adjustments for time were taken in the analysis. With respect to the taxpayer's argument regarding the percentage increase from the previous year in its relation to nearby properties, the arguments remain the original and address the initial decision order. The taxpayer offered no new evidence that would lead to a change in my original decision regarding this issue. The taxpayer does not offer any additional relevant proof to affirmatively value the subject property at her contended value. The taxpayer submitted appraisal while having value at this hearing fails to address questions regarding why no time adjustments was made in its comparative sales analysis, nor why sales from properties closer to the subject property were not used. These issues were raised by the assessor's office. Unfortunately, the taxpayer did not have the appraiser present at the hearing to answer the concerns with a submitted appraisal. The taxpayer failed to carry her burden of proof, and the new evidence introduced failed to support the allegations in her motion. Therefore, the reason set out in the initial decision order, the motion and the motion for reconsideration is denied. He then cites again appeal to this body. I just read that real quick just to know, like, that's also the framework of what's going on, the procedural history of this case. You already heard from Ms. Plants and her contentions about the issues in that order. And Ms. Plants will come back to you too for final comment. But I just want to give the commission. I know Mr. Russ, it looked like you had your hand raised for a question.
Yes, because I've been involved in this on the other side before. The appraiser has to be present in order for him to support his value, his or her value, and submit to cross-examination. And that wasn't there. So that's why the appraiser needs to be there. If you're talking what he did, then you know, it's hearsay. But I do have some questions here about this. I'm confused. The initial order that Mr. Pope read at the very beginning said that the hearing was on December 4th, 2019. Is that correct? And the date that Mr. Cross signed the appraisal was September 15th, 2020. So I don't understand the discrepancy there.
Yeah, so the timeline too, it's in the record. The judge did point that the hearing was held on December 4th, 2019. I don't know if that was particularly accurate as much as the way the administrative record worked for this. There was let me pull it up here, that time frame that might answer your question just based upon the administrative record. Sorry, let me get so we had, let's see here, you had the initial decision order was originally issued on February 10th, 2020. And then the reconsideration where that appraisal was included in the record, that hearing exhibit, Creighton Cross, that was not entered into the record until October 2021. And so you had that initial order, and then there was quite a gap between when the original hearing was held and there was a subsequent hearing on the petition for reconsideration. So you're seeing that.
Oh, okay. All right.
Yeah, I just wanted to clarify. Oh, I'm sorry,
yeah, you can clarify as well.
Sorry. I just wanted, and Judge Pope, you sort of clarified it. We had the initial hearing, and again, I did not have an appraisal at that point because I felt the evidence was strong. Basically, I was sort of told that, well, you basically should have had an appraisal. So I did get an appraisal. and I paid for it, and I brought it to the next hearing. I did not bring Mr. Cross to the hearing, again, because this was the fourth appraisal that I've had on this property, all coming within the reasonable range of what you would expect with market conditions. Although I understand that he was not there to I understand now, I didn't understand it at the time, that he was not there to be cross-examined. I still can use that appraisal as weight of evidence to support my arguments, which I did. I would welcome the opportunity to have him show up. And we can get into why some of that I think is important shortly. But I do think that Judge Cochran overly weighted the fact that he wasn't there based on the amount of other evidence, including the fact that the assessor used comparables that were not comparables. And if he had at least looked at my appraisal, I think he would have seen that those comparables were appropriate for the type of house I have and the consideration. He also, the judge commented that there were no sales in my immediate neighborhood comparable. There was only one sale in my neighborhood, only one. And that is included in Ms. Gass's analysis of square footage, but that house was completely gutted top to bottom. So it did sell for higher square footage amount. But again, you can't just focus on square footage because that one was a complete remodel, gut from top to bottom. It had flooded. And you can't take that square footage and apply it to my square footage and say, my house is worth twice as much as the one across the street. That's not proper valuation principles. It's a mathematical calculation, but it's not proper valuation principles. Thank you.
Thank you.
Yeah, Mr. Prophet, any questions? Mr. Bowles, any questions? All right, this time I'll hand it over to Ms. Gass for her reply. Same thing as before, Ms. Gass, if you could say what you're asking for the commission to do today, affirm, reverse, or remand, and then otherwise the floor is yours for your reply.
Thank you. I'm asking that you uphold Judge Cochran's decision. Ms. Plants mentioned that she had called this office at the last reappraisal, which was in 2019. The prior reappraisal was the 2014. So the difference in value based on price per square foot or base cost house was over a 5-year period. She had appealed before, but that value was effective based off of a prior reappraisal. So all properties in the county did go up significantly. There was, I don't remember what the percentage was, but we've never had a reappraisal that's had less than a 15% increase probably. We have had as much as a 29% increase in value across the board, but the percentage of increase really has nothing to do with the value of a home. That's why we have reappraisals. The playing field, if it was simply the playing field was level and we could go up by a percentage every time, there'd be no reason to do reappraisals. Ms. Plant called in and she, during the review period, which is in April before the county board. So in taking a look at it, and what she failed to tell you was she called in and questioned her appraisal. Well, as with anybody that calls in, we take a look and we look at the house value and the land value. I did increase the land value based off of the sales of vacant land in her subdivision. But what she didn't tell you was that I had lowered the value of her home during that same review, which is typical. That's what we do. She went to, she made the decision to go to the administrative judge. And on the first go around, she was just showing percentages of increases and things in her neighborhood and surrounding area. She did ask for and receive a reconsideration at what point in time she did get an appraisal. She came to the hearing though, and I never received a copy of that appraisal. I never had a chance to look it over or ask either she or the appraiser any questions. She didn't, she brought it in the day of the hearing and I got a copy then, but I never had that opportunity to review or ask questions. On page, let's see, page 21 of the documents that you've got, I think you've showed that before, Mr. Pope.
Yeah. Let me get
That is actually my, workup on her property and her appraisals of comparable homes. Those homes are all comparable. If you will look at that page 21, hers is the first one on the list there, the subject property. And she keeps talking about square footage. Well, we use what's called, assessors use what's called weighted area. And the reason for that weighted area is because we don't get inside of homes, and this is the only way that we really have of comparing apples to apples. If you will scroll on down, let's see, to page 30. Okay, yeah, right there. This tells us what every area of the house, how much weight it carries. So it's not square footage to square footage. And then if you will scroll back up from this weighted area, you will see that, keep going back up, please. Okay, you will see where I have calculated the square foot of weighted area for each one of the comparables and the subject property. And this way I can make it fair when I'm looking at overall area of the home. And let's see, if you go back up then to page 21, we look at all of them are Lake Cove or Lake View. Now, the home that, in my opinion, was most comparable was the property in the subject subdivision straight across the street. It was built in 2006. The subject property was built in 2005. And per Zillow and our own inspection, there was no indication that that home had been gutted and remodeled. The only adjustment that we had to make to that home was for the view, or for the lake, because this one is not on the lake, but it has all of the same amenities as the subject property, the exact same view as the subject property. Now, the other 4 comparables there all are in a significantly less desirable area because Majestic Bay is the most exclusive subdivision in Jefferson County. Was and still is. So Ms. Plants mentioned that Fiddle and Fish Cove was, I think she said 5 acres. Well, the majority, over 4 acres of that is underwater. You have one buildable site. All of these are one buildable site. Now, one of them, the White Oak, there is a little more above, but in that area, there is no sewer, there is no water, and it doesn't perk well, so you have to have larger lots in order to get drain fields in on them. And if the developer could have made the lot smaller, he certainly would have done so. So there's a lot of adjustments. We have some that have let's see, on the 2013 that would be the White Oak property. Right there, I have made an adjustment for the year built. The other 2 homes are older than the comparable or the subject property, and they have effective age because they have all of this is verified on Zillow. But the bottom line is, if you look at the weighted price per square foot of the weighted area, this is our range, and hers is priced toward the lower end of the range. And her first go around, she just talked about percentages of increase. So then when the Judge Cochran gave her a second hearing and she came in with that appraisal, there again, I did not have the opportunity to review the appraisal or ask either she or the judge. And I did have some questions. If you look at page.
No, we don't do questions. It's
Okay,
your time
all
for
right.
just argument. yeah.
Well, I had several questions for the judge that, or for the appraiser that I never got to ask. And she finds flaw with mine, I found flaw with hers, so.
I think at this point, I'm going to ask our commission members, do you have any questions of Ms. Gassie, assessor of property? Mr. Rust, any questions?
Did anyone, when this hearing was scheduled, did anyone from Jefferson County request any documents or appraisals or anything that the taxpayer had?
No, the initial, is this for me? The initial
ma'am.
order said that if she had any evidence that it was supposed to be supplied to me before, and that is in your record. I think that is on page.
It's probably the notice of hearing.
Okay, on page 105,
Okay.
it says that the materials were supposed to have been submitted to me, and they were not.
Okay, thank you.
Mr. Prophet, any questions?
I have one quick question. You referred to the 5-acre tract of going below the water line in Douglas Lake. I mean, I'm sure that's probably somewhere in your record or something. Those lots are common to go below the water line.
You're asking, you can't, were you asking factual questions about?
Yeah, I mean, on that lot, the 5-acre tract, a lot of it's underwater.
Yeah, so if it's not in the record, you can ask for parts of where it was pointed in the record, or we can pull up audio testimony from the hearing, but we're really not getting into
Out in the hearing that 5-acre tract was under the water.
Yes,
so I
sir.
think
The
that's where-
majority of the lot is underwater. Douglas is the only lake in the
Did it
state
come
that
out in the
TVA
hearing?
did not acquire.
It did. And did you make
easement.
that?
They simply
did
leased
that come
it.
up? Did that come up at the hearing with Judge Cochran?
Yes. I bring it up at all of my hearings because we are unique.
Okay.
Mr. Bowles, any questions?
I don't have any.
No. All right. All right, Ms. Gass, I'll hand it back over to you for your final comments before we go back to Ms. Plants. Again, just try to keep it focused on I know we're getting a little bit really into the weeds here about kind of what happened, the evidence, what was presented, when, we're really talking about the decision of the judge. Did you think the decision was incorrectly or correctly decided, and why? It's all we also got some time restraints here. We still have one more hearing of the day, and we do have some time restraints on this room access. So if you could make your final comments, we'll go back to Ms. Plants for her final comments.
I feel like the appraisal that was done on her property is very reasonable, considering the location of her home and the overall quality of her home. I think that the value is very reasonable.
Thank you. And then Ms. Plants, we'll hand it back to you for your final response before we enter deliberations.
Thank you. One basic comment. If the assessor is using Zillow as a technical resource, that would not be correct to do so. Zillow uses algorithms, many of which are incorrect, and that is widely known. If you sell a home.
Okay, Ms. Plants, I'm sorry. I just, again, we're just
sorry.
really here to hear about the decision of the judge. I know,
Okay, that's fine.
obviously
That's fine.
Ms. Gass made some comments about, but we're really talking about that decision, your final comments about why you, I guess, in your terms, why you believe that decision was incorrectly decided.
Yes, and again, I strongly stand behind those homes. The 5 acres are not completely underwater. There is at least 2 acres above water. If you look at the real estate listing for that, Ms. Gass is shaking her head, but the real estate listing for that home basically will say 5 rolling acres. So there's a disconnect there. The fact that the home across the street has been remodeled, that was known, and I believe that was in the record of the previous hearing. At least it was in the original record where I commented it had been remodeled. So she was aware of that. Second, again, I strongly feel that my appraisal is appropriate and that the evidence weighted. I'm not arguing, Judge Cochran referenced the Kissel case again. I'm absolutely not making that argument. I am well-versed in valuation theory. I know what the Kissel case is. I'm not arguing that my increase is irrational without cause. I'm arguing it's irrational based on market conditions, based on no improvements, and based on what my valuation has indicated. And although I mistakenly did not have Creighton Cross stand in and support his valuation, I could easily do that. And the other item that I think is relevant here to some extent is at the conclusion of, again, this process needs to be fair to the taxpayer. I've struggled with this for the past couple of times. There is a level of inappropriate, almost abusive power aggression here. Subsequent to these hearings, Ms. Gass filed a complaint against my appraiser through the channels.
As plans, I just really want to get into parts of that, if that's in the record, and or we're really just here for the decision.
Okay, well, I think that's relevant because it was basically the appraiser stood as it was, without change. So I think I commissioned the fourth appraisal on this home that came within what I would think is a fair market value range with 4 separate appraisals. The first one, again, struggling to get my loan. I actually had the opposite issue because I couldn't get it up. The other issue is to further show that these homes are not similar to mine. The Troutline home that was listed with 5 acres and 400 feet of shoreline, 400 feet of main channel shoreline. While my home was on the courthouse steps getting sold for $525,000, that home was being listed for 1.2 million. Now, because again, the time frame that it takes to sell larger in homes in this area, unlike Nashville, where there's huge industry, there's a limited demand for homes in this area that are north of 500,000, say. It took a long time to sell, but you cannot say a home that went into foreclosure and couldn't even sell for above 525 is similar to a home that was listed for $1.2 million. There's differences there. And simply by looking at this sheet, I can understand why Judge Cochran may not understand that and may not have been able to take the time and do the due diligence to see the differences, but there are significant differences that should have been considered.
Thank you.
Thank you so
With that,
much.
we'll enter deliberations. There'll be no more communication between the commission and our parties. Mr. Russ, as our presiding member, I'll hand it off to you. We are running in a little bit more time constraint, so.
Not motion, but I am concerned at the information of the appraisal, which was an excellent appraisal. Ross did a very, very good job. He wasn't there and defended, and more importantly, the county had not seen it. So, like it or not, these are adversarial. I mean, that's how we come to the discussion of what the value is worth. And so I've got a real problem with that. I'm fairly, not fairly, I'm inclined to all judges. I do want to hear what.
Okay. I agree. The concern is which could have been answered if the appraiser had came, why he used sales from other areas when it appears there's some information there close by. I mean, we always grasp for anything close, especially in the subdivision. You know, it's if you've got something like that, you can work with it, and someone with that good of skills as he has, I mean, have been able to do the adjustments and stuff. It concerns me, and I'm sure he could have had a explanation for that if he had been there. I just can't see how we could use that. I mean, with that in mind, it looks like, from my view, that the administrative judge made the right decision.
Mr. Bowles?
Yeah, I too think that probably is the case, that with the information they had at the time and in making the decision. Probably
Oh, Mr. Bowles, I dropped you on the mic.
and made his decision based on, what he saw. I think they were both good reports, it looks like. Certainly they would stand up to a good review, so I think it could be a timing situation, and I can't fault the judge for that.
Would you like to make a motion, Mr. Bowles or Mr. Prophet, either?
Make a motion that we affirm the administrative judge decision.
I second the motion.
Mr. Prophet seconds. All those in favor say aye. Aye. Any opposed? Thank you.
Decision is unanimous. The decision of the administrative law judge is affirmed. We will send out a final written copy of the day within the next 90 days, and then I'll identify your remedies after that. That concludes the business for Kelly Plants versus the Jefferson County Assessors of Property. Both of you are excused. We will move on to our next case. You're also welcome to stay and observe. It is an open meeting. We have 10 Roads Express versus the Office of State Assessed Properties. Do any of our commission members, do you need a break before we go? We don't have a lot of time, but if you need a break, we can. We're ready to go? Okay, yeah. Ms. Thornberry, I see you are there. Mr. Sharp is walking up to the podium. I will pull that up. Okay, our next case is the matter of 10 Roads Express LLC is the appellant to the commission versus the Office of State Assessed Properties is the respondent here. We have APD case number 53.08-22408-9J for State Board of Equalization case number 137913. The parcel or tax ID here is the tax ID used by the Office of Assessed Properties. That is MC178785. This is for tax year 2021. I previously sent out a copy of the notice of the administrative record on February 9th, 2024. The record in this case consists of approximately 270, 5 pages, plus a two-page introductory of the notice, beginning with a May 1st, 2023 certified technical record, followed by a June 16th notice of scheduling conference, followed by a December 19th, 2023 notice of hearing before the commission. That's the hearing for today. Followed by a January 24th, 2024 taxpayers argument filed, and then a January 30th, 2024 Office of State Assessed Properties argument filed. The certified technical record, I'm going to read the initial decision in order. In this case, which was issued on February 24th, 2023, starting with the introductory letter, and then beginning with the order, same case caption as I previously read. On January 20th, 2022, the taxpayer filed a direct appeal of the tax year 21 forced assessment to the State Board of Equalization, hereinafter State Board. The taxpayer did not appeal to the Comptroller of the Treasury and the State Board of Equalization. The undersigned administrative judge conducted a telephonic jurisdictional hearing on December 6, 2022, the taxpayer, 10 Roads Express, was represented by its attorneys, Madison Thornberry and John Whitworth. Hereinafter, the taxpayer, the Tennessee Comptroller's Office, was represented by Assistant General Counsel John Sharp. Hereinafter, the Comptroller's Office. The testimony of the taxpayer, CFO, Mike James, and a senior specialist with the Office of State Assessed Properties, Lowell Robinson, and the following exhibits were introduced at the hearing. Exhibit 1, the taxpayer's documents. Exhibit 2, the taxpayer's company snapshot. Exhibit 3, 2021 certification of valuation by the Tennessee Comptroller's Office. And Exhibit 4, a list of the taxpayer's drivers with Tennessee driving licenses as of November 2020. In this case, the taxpayer testified at the hearing that notice of forced assessment and appeal rights were never received and were not informed of the forced assessment until after the deadline had expired. The assessor's office testified that all statutory requirements imposing a forced assessment and for mailing of the notice of the forced assessment to the taxpayer were complied with, and the taxpayer failed to timely file an exception to the forced assessment. And due to this fact, the administrative judge has no jurisdiction to hear this matter due to the state board issuing a final certification. Upon review of the record, the administrative judge agrees with the Tennessee Comptroller's Office and finds no jurisdiction in this matter to modify the force. The taxpayer is an interstate motor carrier that operates trucks within several states, including the state of Tennessee. The Tennessee Office of State Assessed Properties, hereinafter OSAP, is charged with assessing, appraising, and auditing public utilities that have a presence in Tennessee. And then at footnote 1, he cites the code provision for that. The taxpayer was required to file with OSAP an ad valorem tax report annually on or before April 1st, then cites the code provision for that, and failed to do so, resulting in OSAP placing a forced assessment on the taxpayer as required by statute. Again, a footnote for the citation for tax year 2021. OSAP notified the taxpayer of the forced assessment by 2 notices delivered by United States Mail Service before August 2nd in compliance with the statute. Then final footnote 4 cites the statute citation there. There was no evidence presented that OSAP failed to provide notice to the taxpayer of the forced assessment. Further, the taxpayer failed to file an exception to the OSAP assessment with the Tennessee Comptroller and the 10-day period allowed. And the final footnote, the citation for that. The Tennessee Comptroller's Office convened a hearing on this matter on August 18th, 2020, and the taxpayer failed to appear, leading to the Tennessee Comptroller's Office to certify the forced assessment. After certification of a assessment by the Tennessee Comptroller's Office, the taxpayer could have an exception or challenged the forced assessment before the State Board of Equalization on or before 20 days from the first Monday in September. And cites the citation for that. The taxpayer failed to file an exception or appear before the State Board at its October 13th, 2021 meeting, where the board certified the forced assessment of $8,492,500. All actions by the State Board with respect to certification of valuation are deemed, quote, conclusive and final, end quote. And then the final footnote with a citation for that. Tennessee statutes are clear with respect to the authority of the OSAP to levy forced assessments and the rights of taxpayers to challenge the forced assessments. There was no evidence presented that OSAP did not meet their statutory duties with respect to the forced assessment and providing notice and providing of notice to the taxpayer of the assessment and their appeal rights. Regrettably, the taxpayer, while not intentional, failed to avail themselves of the appeal rights despite multiple opportunities to do so. As the party seeking to change the current assessment, the taxpayer has the burden of proof in this administrative proceeding. And citing the State Board rule on that, the taxpayer has not met their burden of proof in this matter, the State Board having made a certification of this assessment that is conclusive and final, gives me no statutory basis for jurisdiction over this matter. Therefore, the taxpayer appeal is dismissed. It is so ordered, this initial order being entered and effective the 24th day of February, 2023, entered by Administrative Judge Jerome Cochran. Concludes the next page on the signature, and the page after that, appeal remedies, including appeal to this body, which is why we are here today. That being the administrative record and the initial decision up for review, this is our last case of the day. We have just enough time before we need to be out of this room. With that said, I will hand it off to Ms. Thornberry for introductions. And like everyone else, Ms. Thornberry, if you could identify what you're asking permission to do today, but then otherwise the floor is yours for your argument. I know you said you allocated about an hour for your argument. I will stop talking and the floor is yours.
What are your time constraints? What time do you need to be out of there?
Like one, hopefully maybe like 1:15.
Oh, okay. Well, I will streamline this. Just bear with me a little bit if I jump around, but I think I can do much better than an hour.
Yeah, and like I said, if I need to highlight any parts of the record, or I need to pull anything up, like I've done the last 2 cases, or we even have the audio recording if we need to play a snippet, I can absolutely do that.
Okay, sounds good. Well, my name is Madison Thornberry. I'm here on behalf of 10 Roads Express, seeking a reversal of the initial order Mr. Pope just read to you. Want to first thank you all for your time today and Mr. Pope for his efforts in getting this scheduled. I know your time is precious as you're trying to get these matters and hearings up before the end of the year. So I am trying to really shorten this up, keep it sweet and painless. I would joke that I can't say the same for John and say, you know, he intends to make it painful, but my experience with him is that he's been great to work with. So I think you're probably good there too. As some initial background, Ten Roads is a motor carrier that primarily hauls mail for the Postal Service. What I mean by that is not that our drivers are delivering letters to your mailboxes. They're performing a lot of the over-the-road work, delivering mail from post office to post office, where then it's ultimately delivered to you. Although Ten Roads has a fairly large presence in the mail hauling sphere, it's a relatively new company and young. It's actually just formed in the fall of 2020, and it didn't begin operating as a motor carrier until January 1, 2021. So, unfortunately, that newness and that that timing kind of led to where we are today. In late 2020, Ten Roads received a notice from the state of Tennessee that it would be subject to ad valorem taxes for the year of 2021. A mistake that I wish wouldn't have happened. We did not file that report, and OSAP ultimately assessed ad valorem taxes against Ten Roads with an assessment value of over $8 million. You know, we're not here today arguing that OSAP wasn't authorized to place such a forced assessment. Instead, our argument is that Ten Roads never received proper notice of the forced assessment, and because of that, it was deprived of its constitutional and statutory rights. We're also arguing that because of that, the ALJ's dismissal of the value appeal and failure to make any findings as to whether we actually received notice of the forced assessment was arbitrary and capricious and unsupported by substantial and material evidence in the record. The ALJ, as you heard, found that OSAP met its statutory burden to send notice to Ten Roads, and because of that, he was without jurisdiction to hear the appeal. In my opinion, that finding completely misses the point of the appeal. You know, we're not arguing that OSAP didn't send the notice. We're arguing instead that Ten Roads never received it. I think if you look at the statutory scheme, it's kind of a give and take. There's two parts to it. If you look at Tennessee statute 67-5-1327, subsection A provides that OSAP is required to send notice of a forced assessment by the first Monday in August. But then you go down to subsection B, and that's the portion that gives the taxpayer a right to file an exception to that within 10 days. It's kind of common sense that you can't file an exception to something that you have no notice of. So inherently, there's built in an assumption that the taxpayer is actually going to receive that notice that's sent by OSAP. You know, this right to notice, to actually receive it, and the opportunity to object is a fundamental right, which is necessary to ensure that taxpayers are not deprived of their due process rights. In fact, the Tennessee Court of Appeals has held that determining whether the taxpayer actually received notice, the notice required by 1327 subsection A, is required to satisfy the requirements of due process. The case that holds that is Volunteer Princess Cruises versus the Tennessee State Board of Equalization. Happy to give you that case number, but it is in the written materials, so I'll shorten it by not giving you that number and the date. But it's, you know, for this reason, this right to actually receive notice being a fundamental right, that the statutory scheme further underscores the taxpayer's right by providing a carve out for taxpayers who never received notice to be able to kind of escape the procedural need to first file their appeal with the local board of equalization. That exception is found in Tennessee statute 67-5-1412B. That statute gave the ALJ jurisdiction to hear the appeal because we never received notice of the forced assessment, and that was the basis of our argument. I think that statute obviously provided jurisdiction in the appeal, and at least should have prompted the ALJ to, you know, find out whether he had jurisdiction, he had to find out whether the actual notice was received. Because of this inherent requirement and this court-ordered requirement that it be determined whether Tin Roads actually received notice of a forced assessment, the ALJs deprived Tin Roads of this constitutional right and statutory rights by making no determination as to whether Tin Roads actually received notice. This deprivation of a fundamental constitutional right to due process, I think, is further arbitrary and capricious due to, the fact that Tin Roads expressly requested the ALJ to make such a finding in the hearing. We cited this case, Volunteer Princess Cruises, and we specifically told the ALJ that you have to find, or you have to make a determination as to whether we actually received notice. Second, I think there's substantial and material evidence in the record to demonstrate that Tin Roads never did actually receive notice. To elaborate on that, there's 2 documents out there that OSAP contends gave Tin Roads notice of the forced assessment. One of those would be an email, which you can find on page 176 of the administrative record. And I'll give Mr. Pope a minute to pull that up.
Let me pull that up.
Sorry,
Yeah,
I know I'm talking
176.
really fast.
Oh, you just caught me. Sorry. Is it 176?
176.
Exhibit 6.
No, I would have gotten her numbered differently.
Oh, no, sorry. No, this one, 170.
Okay, yeah.
Does this look right?
Yes, that's it.
0,
I'm
1,
sorry.
Okay.
That is it right there. This is the email that OSAP contends on one hand provided Tin Roads notice of the forced assessment. I think you can see on its face that this email is not proper notice of the forced assessment. It even says that a formal notice will later be received. So that by its very, very terms is telling you that this is an informal notice. This is not a formal notice. It additionally is sent to an individual, and this was kind of borne out in the hearing, an individual that has no affiliation with Tin Roads' tax or accounting departments. It's an employee that works and resides in Florida, or used to, had no ties to Tin Roads operations in Tennessee, just was not a proper person to receive this notice. And finally, this email just doesn't provide any necessary information. All it provides is, this informal statement of what the assessment value is, but it doesn't provide any other necessary information. Specifically, it doesn't cite to the comptroller's authority to impose this forced assessment. It doesn't advise us that the records are open for inspection. It doesn't advise us of the right to appear and file exceptions. Doesn't provide any notice that failure to do so within 10 days would result in a waiver of the right to file exceptions. And these are all items that are all pieces of information that are typically included in OSAP's standard and typical notice of forced assessment that it sends out. The second item that OSAP relies on to argue or that Tin Roads received notice of the forced assessment is a letter that was sent to Tin Roads on August 2nd, 2021. That letter is on page 178. Mr. Pope, if you're able to get there. However, this letter, again, failed to provide Tin Roads the statutorily required notice of a forced assessment because Tin Roads never actually received it. At the hearing, Tin Roads presented evidence through the testimony of its CFO, Mike James, supporting the same. In response, OSAP hasn't produced any proof of mailing, any return receipt, nothing at all to prove that this letter was actually put in the mail, much less actually received by Tin Roads. So, regardless of whether OSAP sent the letter, there's nothing to demonstrate that Tin Roads actually received it. Third, I think the ALJ's decision deprived Tin Roads' constitutional and statutory rights to due process because it is completely contrary to the Tennessee Court of Appeals decision in Volunteer Princess Cruise Lines. That is a case that is almost identical to our facts at hand. The Tennessee Court of Appeals upheld the taxpayer's right to actually receive notice, not just for OSAP to send it. The taxpayer has to actually receive it so the taxpayer knows whether or not to object to it. In that case, although OSAP produced copies of notice letters required by that statutory section 1327, the taxpayer testified that he never recalled receiving it. Didn't recall ever receiving it prior to when the deadlines arose when he would need to file the exceptions. And in fact, the taxpayer testified that although he had seen the letters and the orders at issue, he had no recollection of ever receiving them, seeing them, or obtaining a copy of them from any source within any matter of time, which would have allowed him to act on them. And he actually had never seen them until they were provided during the course of his tax appeal. The taxpayer further testified that if he had seen the required letters and notices providing notice of the forced assessment, he would have taken appropriate action. Based on that evidence presented to the Tennessee Court of Appeals, the court held that to avoid a violation of the taxpayer's constitutional due process rights, the Court of Appeals vacated the board's dismissal of the taxpayer's appeal and held that on remand, the board must determine whether the taxpayer actually received notice sufficient to satisfy the requirements of due process. So, that case very clearly lays out that not only does OSAP have to send the notices, but the ALJ also has to make a determination of whether the taxpayer actually received the notice. It's a two-part question. You can't just answer one and decline to answer the second question. Despite Tin Roads citing this case, which is directly on point to the facts at hand, the ALJ failed to make any determination whatsoever as to whether Tin Roads received notice sufficient to satisfy the requirements of due process. Despite specifically noting in his order that Tin Roads testified at the hearing that notice of the forced assessment and appeal were never received, and Tin Roads wasn't informed of the forced assessment until after the deadline had expired. Additionally, Tin Roads produced testimony that had it received the notices of the forced assessment timely, it would have taken appropriate action. It would have Tin Roads CFO again testified that Tin Roads has a process for evaluating forced assessments when they come in, determining if they're the right value, and then acting upon the same. That testimony was accompanied by the CFO's testimony as to how we got here today. When we finally did receive a tax bill in this matter over a year later, that bill, because Tin Roads didn't know the basis of it, and I'm sorry, I am jumping around to try to speed this up for you guys a little bit.
I think you're good. We got time.
Okay, page 109 and 110. I think the email chain starts on 110 and then rolls up to 109, if I remember correctly.
Yep.
Yeah, so I think it maybe all fits on 109 and there's just a signature or something on 110. But this email chain evidence is when Tin Roads first became aware of the forced assessment value, and that was through a bill that it received at the end of December 2021. This also kind of evidences Tin Roads' process for how it assesses tax bills and tax assessments. This was immediately forwarded to our CFO, not the first forward, but the second forward, who then, he testified that as soon as he received this, he immediately and promptly took a number of actions to address this. First he calculated what our actual ad valorem tax assessment value should have been for the year of 2021 using OSAP's own motor carrier ad valorem tax report. A copy of that worksheet that he completed can be found on pages 111 through 121. In completing this worksheet, Ten-Road's CFO immediately found that the assessment value should have only been, it's right over 2 million. So, at that point, he compared to that number with the forced assessment value, which, if you remember, was over 8 million, immediately triggered that there is something wrong here. So because of this massive discrepancy, our CFO testified that his second action was to immediately contact the comptroller to discuss the basis of where this value came from. That conversation is evidenced pages 126 through 129 of the record, where I won't read every word to you, just kind of giving you an idea of where you can look. So this was just within days of when that bill was forwarded to Mike James on January 3rd. This conversation is happening on January 6th. He's trying to figure out where the basis of this forced assessment value came from, how we were ever provided notice of it. And OSAP is referencing the prior email that we looked at earlier, providing notice to the employee in Florida. Third, after this conversation with the comptroller, Ten-Road's CFO testified that he then paid all undisputed taxes sought by the Tennessee counties and municipalities that imposed 2021 ad valorem taxes. And then finally, Ten-Road's promptly filed the value appeal that has brought us here today. So just like in Volunteer Princess Cruise Lines, in addition to the testimony and the substantial evidence that Ten-Roads never actually received notice of the forced assessment, Ten-Roads also put forth substantial material evidence that had it received notice, it would have acted on the same. It would have filed exceptions. It would have filed objections. But Ten-Roads was deprived of those rights and deprived of those opportunities because it did not ever receive a forced assessment. Ultimately, whether OSAP sent the required notice and whether Ten-Roads actually received it are two separate questions that the ALJ was required to answer based on the statutory structure and the Tennessee Court of Appeals holding and Volunteer Princess Cruise Lines. And unfortunately, if either of those questions is answered in the negative, the taxpayer has been deprived of its due process rights. Here, despite being specifically asked to answer those two questions and despite the substantial and material evidence presented to the ALJ regarding whether Ten-Roads has actually provided notice or actually received notice, the ALJ's order, declines to answer both questions. It stops short of it and just only answers whether OSAP sent the notice. It never touches on whether Ten-Roads actually received it, despite citing testimony that was put forth that Ten-Roads never received evidence. This ruling thus deprives Ten-Roads of its rights to due process by failing to even consider whether Ten-Roads actually received notice. And it's given the substantial and material evidence regarding whether we received notice, the ruling is also arbitrary and capricious. I think that I can sum it up there. So in light of all of this evidence and this specific request to the ALJ to make a finding as to whether we actually received notice to meet our, provide us with our due process rights, the ALJ's failure to make such a finding or even consider it was arbitrary and capricious. So for these reasons, Ten-Roads respectfully request that the order be reversed. Happy to answer
right.
questions. I know I was talking very
Well, you
fast.
took it out of my mouth. I was about to be like, any questions for for the 10 roads? I'll start with Mr. Rust. Any questions?
I do have a couple here, and if I straight into getting the wrong area instead of just what's in the record, but it says here, this is on page 36, that 10 roads, that someone from Mr. Robinson sent a letter to 10 roads explaining to him that, or explaining to you that you'd have to file personalty taxes, ad valorem taxes, and that he sent the information by certified letter. And that was, I guess, in January or whatever of 2021, but it would be due by the appropriate dates in 2021. And why would, when they got this, why would they just wait? And it said that they didn't hear anything else. Well, why would you not follow up on something like this? If
So,
you mail this to me, or
so what page? Sorry.
this would be in the blue.
Oh, the blue one.
Blue. It's page 36.
Oh, as part of the taxpayers appeal?
Yes.
Happy to
then
answer that.
some of the other stuff in here that you're getting emails that such and such would have been sent and hadn't received them, but why not follow up on that? That I don't really quite understand. You're talking about a lot of money here that you might or might not be liable for, to try and ascertain when it's really due and how much and what can we do to send in our information.
So to start with your first question, the certified letter that you're referencing was sent in December of 2020. At that time, 10 Roads was not operating as a motor carrier. It did not own or lease any property in the state of Tennessee. I think there was testimony at the hearing that 10 Roads believes it was just human error. Someone got this notice and thought that because 10 Roads was not operating as a motor carrier, they weren't required to file the ad valorem tax report in 2021. With that being said, there's no dispute as to whether or not we filed the ad valorem tax assessment report in 2021, but that's not the issue on appeal today. The issue is whether we received notice of the forced assessment. And that letter, the forced assessment wasn't put into place until months later after the certified letter was sent, and the letter purporting to provide notice of the forced assessment was not sent certified mail. It was not sent registered mail. We never received that. Your second question regarding the email, that email went to an individual who, again, is just not part of tax and accounting department. I think the testimony was clear at the hearing that individual just probably looked at that, probably thought it was spam, didn't know what it was, not something that he dealt with. And again, probably just human error. In Florida has nothing to do with the state of Tennessee, has nothing to do with 10 Roads operations in the state of Tennessee. Again, I think that misses the ultimate issue on the appeal as to whether we received the actual notice of the forced assessment, which that email is not. That email says that it's, formal notice will follow. And it doesn't provide 10 Roads any notice of its rights. So if you get an email saying formal notice will come, formal notice will follow, your thinking at that time is probably like, oh, action isn't required of me at this time because this isn't a formal notice. So does that answer your questions?
Thank you.
Mr. Prophet, any questions?
So 10 Roads started, according to your testimony earlier, and apparently in the record, basically doing business as a company here in 2021. Is that correct, or 2020?
Well, the entity was formed in 2020. Formally, the entity was created in 2020. I think we registered in the state of Tennessee John can probably correct me with the exact month, but in the fall of 2020 is when we filed with the Secretary of State in Tennessee to be authorized to conduct business there. However, 10 Roads didn't actually start employing drivers or doing any business until 2021.
10 Roads has existed as a company in other areas other than Tennessee prior to that.
No, sir. No, sir. 10 Roads was formed, like the company came into existence in the state of Delaware. And I don't want to tell you the wrong thing, but a month in 2020. And then thereafter, we slowly got authority with each state Secretary of State to conduct business in the states. So essentially, we're just doing preliminary formation, getting our ducks in a row in 2020, but business didn't start out. We didn't actually start operating until January 1, 2021. That was the go live date, if you will. Yes, sir.
Mr. Bowles, any questions?
No, I don't.
No? Okay. With that, no other follow-up questions from our commission. We'll hand it over to Mr. Sharp for introduction, and same thing, if you could identify what you're asking for the commission to do today, and then otherwise the floor is yours.
Good morning, and thank you for your time here today. I appreciate your service to this commission. My name is John Sharp. I'm an Assistant General Counsel for the Comptroller of the Treasury. I'm appearing here today representing the Office of State Assessed Properties. I commonly refer to that entity as OSAP. And today we believe, OSAP believes that the administrative judge got it right. We are asking that you affirm the administrative judge's initial order, finding that there is no jurisdiction to hear this appeal. This is an appeal of a forced assessment, not unlike other appeals of forced assessments this commission has heard. Forced assessments typically arise in the assessments of self-reporting taxpayers. There's two instances that I can think of. OSAP, those taxpayers, those business entities, they self-report to OSAP. The other instance that you've probably heard appeals about are business taxpayers, where they self-report their tangible personal property. Otherwise, the assessing entity goes out and comes up with a value for it, and it's not a self-reporting tax. The law requires an assessing authority to force assess if no schedule is received from a taxpayer, and that's what happened in this entity. In this instance, OSAP did not hear back, and talking about, I'm going to refer back to several sheets that we've mentioned before earlier, and the first would be on page 106, Secretary Pope. And as was mentioned earlier, there was a filing with the Secretary of State. So OSAP has two duties: to identify these companies that are operating within Tennessee, and then to come up with a value for those companies. When that filing with the Secretary of State triggered OSAP to be aware that there was a new company looking to operate in Tennessee. OSAP, on December the 10th of 2020, before the company became live, as they've said, on 1/1 of 2021, a certified letter was sent, and on the second page on 107 is the documentation that shows it was signed for there and received in their office. And it says it's mailed to their office, 10 Roads Express, LLC, Attention Tax, 2020 Abbott Drive, Carter Lake, Iowa, 51510. And there's been no evidence or no testimony that that's not their correct mailing address. And it says 2021 ad valorem report. It has been determined that 10 Roads Express is subject to ad valorem assessment by the Tennessee Comptroller of the Treasury for 2021. Tennessee Code Annotated Section 67.5.1301 requires companies granted operating authority from the Federal Highway Administration and or the former Interstate Commerce Commission or the Tennessee Department of Safety and who are domiciled in this state and or who lease or own property located in Tennessee, including owner-operators, to file the ad valorem tax report. And that was mailed to their certified mail to their mailing address. On the enclosed filer is our website address where you can do the report online or print the forms and do the report manually. Failure to file a complete report will result in a forced assessment in accordance with Tennessee Code Annotated Section 67.5.13.7. If you have any questions, concerns, please contact me, and it provides a phone number and the name. Sincerely, Lowell Robinson, and he's the auditor assigned to those trucking companies. So that notice was sent to 10 Roads, and as has been testified to, there was no response to that notice. The taxpayer was forced to assess. Subsequently was forced to assess. Notice was sent on August 18th, 2021. There was a public hearing, and notice was sent of that public hearing to that same address. They were 10 Roads. The taxpayer did not appear at that public hearing and did not file an exception. An exception would be an appeal. That's the terminology that the statute uses, exception, and it correlates to an appeal. There were companies that did come. OSAP sends those mailers out, and they sent it out prior to that meeting. Secretary Pope, I'm at page 178. Yes, there's the same address. 10 Roads Express LLC, 2022 Abbott Drive, 2200 Abbott Drive, Carter Lake, Iowa, 51510. And there's the notice that provides them the amount of the assessment, the fact that their records are open, and the statute authorizing OSAP, and that's sent by the director of OSAP. OSAP sends these out to every company that they assess. They do not send these certified mail. The statute makes no requirement that we prove that the taxpayer received the mailing. The statute only requires that we can prove that it was mailed. There's the documentation that was mailed. That hearing was held on August 18th. At 9:30 a.m. in this building. For state assessed properties, the companies that OSAP deals with, there's a two-part process. That initial hearing that was held in August is called the informal hearing. After that informal hearing, the second part of the process is it then goes to the full state board. There was a notice sent of that as well. And there was a full hearing before the state board on October 13th of 2021. Once again, the taxpayer did not show up and did not file an exception to that hearing. That those assessments were approved by the full state board, and that was done shortly after that October 13th, 2021 hearing. The taxpayer raises the issue of that we've got to show that there was their company received notice. I disagree with that. They cite Volunteer Princess. I was involved in Volunteer Princess. That was a case that I was representing OSAP in. There were multiple years and there were multiple findings in that decision. The court did, and I'll read the language if that's agreeable. The court said, thus we conclude that the board must determine whether Volunteer received sufficient notice to satisfy the requirements of due process, and this requires a credibility determination with regard to the testimony of Mr. Hurley, a determination which the ALJ, as the finder of fact, is in the best position to make. Mr. Hurley was one of the witnesses, and he intimated during the hearing that he didn't receive the mailings. He didn't ever get them. For some years, they said that didn't apply. That there was sufficient evidence in there that he didn't get the mailings. But for that 1 year, 2008, I believe it was, there was nothing in the hearing about that, the administrative judge's decision. That's not the case here. I would distinguish this case. We've got evidence in this case that was presented before the administrative law judge about these notices. I'm going to refer you back to first notice, and that's on page 175, actually 176. And on page 176, you can see just below the logo there, it says from Lowell Robinson, and it says sent Tuesday, July 20th, 2021, to D. Tucker at 10roadsexpress.com. A forced assessment relating to the above named subject has been enacted in the amount of $8,452,500 for 10 Roads Express LLC. You will later receive a formal notice in writing. Mr. Robinson testified that he went to the website and it said, contact us. And this is the name that came up, and he sent that email to that individual. The formal notice is the one that I showed earlier that was sent on August the 2nd, that was sent to the home address where the certified letter that was sent early and back in December was sent. Mr. Robinson sent this with a Microsoft feature. This came out in the testimony at the hearing that shows when an email is read. And that was entered into evidence that showed that that email had been read. It was a read receipt. If you look on page 175, this is an email from, thank you. This is an email from the CEO, Mr. Mike James of that company. And he testified at the hearing. And the administrative law judge heard his testimony. And he was asked about this. And he's saying, yes, we do have D. Tuckers. And he thinks he figures it out. But it shouldn't go, the email shouldn't go to him. We would never have received the assessment that was mailed. However, as it went to Iowa, looks like a plethora of ball drops on our end, with everyone in the chain thinking someone else was handling a mess created when rolling 3 companies together as responsibilities were changing at the same time. The judge heard that testimony and made a credibility determination. And he determined, based on the evidence in the record, that 10 roads received their mailings from OSAP. He made that determination. Referring back to the initial order that Judge Cochran on page 29, where he says in the opening paragraph, the undersigned administrative judge conducted a telephonic jurisdictional hearing on December 6th. The taxpayer 10 Roads Express LLC was represented by its attorneys, Madison Thornberry and John Whitworth. Skipping down, the testimony of the taxpayer CFO, Mike James, and skipping forward, and the following exhibits were introduced into hearing. In this case, the taxpayer testified at the hearing that notice of the forced assessment and appeal rights were never received and were not informed of the forced assessment until after the deadline had expired. That's what Ms. Thornberry has said again today. However, the judge says, upon review of the record on the next page, 2 of 4, page 30.
Okay.
30. The second paragraph there. Yes, thank you. On review of the record, the administrative judge agrees with the Tennessee Comptroller's Office and finds no jurisdiction in this matter to modify the forced assessment. On the page 3 of 4, on page 31, paragraph there, regrettably, the taxpayer, while not intentional, failed to avail themselves of their appeal rights despite multiple opportunities to do so. That's the credibility determination. They had the materials. They did not file the appeals. Of course. One final point I would make, and this is, it's always difficult in dealing with a forced assessment. That's why the penalties are there for the forced assessment. OSAP would rather receive the information from the taxpayer and then take that information that the taxpayer submits to determine the assessment. They did not have that information in this case, so they have to do the best they can. And that's what they did in this instance. Ms. Thornberry has said that the taxpayer has calculated a value. That's not the taxpayer's purview. They're not responsible for calculating a value. They're responsible for supplying the information, and then OSAP calculates the value. We don't know that that value that they've provided is accurate or would be the true assessment. The process is to submit the information to OSAP, and then they determine the value. If the taxpayer doesn't agree with the value, then there's 2 separate opportunities to file an exception to that. The administrative judge has broad discretion on evidentiary issues concerning questions of fact and has previously considered the taxpayer's evidence. We believe the role of the Assessment Appeals Commission is clear when it comes to weighing the evidence on questions of fact. The commission cannot substitute its judgment for that of the administrative judge. The administrative judge's order establishes both parties' evidence was considered and weighed. The administrative judge found the taxpayer's evidence insufficient to grant jurisdiction. The decision of the administrative judge was supported by the evidence in the record, and the taxpayer has not shown its rights were prejudiced for any of the reasons established in Tennessee Code annotated 67-5-1506. We would ask that you affirm the administrative judge's decision. And I'm open to any questions that you have or anything that you wonder about.
Mr. Russ, any questions?
I don't have any questions.
Mr. Prophet,
I have no questions.
Mr. Bowles?
I have no question.
All right, with that, we'll hand it back to Ms. Thornberry for your final response and final comments before we enter deliberations.
Okay, I just want to underscore that Ten Roads is not trying to hold out any payment of taxes from the state of Tennessee. We have paid all undisputed portion of these taxes. Outside of that, this assessment value this forced assessment value that OSAP is trying to defend is based on every vehicle in Ten Roads fleet nationwide. They've included that in this forced assessment value, regardless of whether that vehicle has ever been in the state of Tennessee, has ever been driven by a Tennessee driver, has ever conducted any business in the state of Tennessee. In subsequent years, Ten Roads has used the same method that it used in that worksheet we provided earlier for its ad valorem tax reports, and the state of Tennessee has had no issues with that. There's no years subsequent that we're having any fight about these ad valorem taxes. It's just this 2021 year. And you know, we're not arguing that an error wasn't made. We recognize that an error was made in not initially filing this ad valorem tax report, and that's just human error. But your Tennessee statutory scheme is designed to catch that thing. That's why this process is put in place for OSAP to be able to impose forced assessments. But that process is also designed so that there's checks and balances. You know, to the extent that OSAP does impose a forced assessment, there's a requirement that it provide notice to the taxpayer so that the taxpayer has an opportunity to review it and accept it. You know, with that being said, I think anything that occurred prior to, you know, we're not contending that the December 2020 notice wasn't received. We're not contending that we didn't make an error in not filing the 2021 ad valorem tax report initially. All we're saying is that once OSAP imposed the forced assessment, we were entitled to proper notice to it. That right to actually receive notice is a constitutional and statutory right. Mr. Sharp cited language to you from Volunteer Princess Cruises saying that the determination of whether that notice received requires a credibility determination by the ALJ. That is what I specifically asked the ALJ for. That is why I'm asking you to reverse this, because that order doesn't make that credibility determination. All that order focuses on is whether OSAP sent the notice. It doesn't touch at all on whether Ten Roads actually received the notice. That's what we're asking for. Mr. Sharp says that they sent notice, so we received it because it went to this address. I say that we didn't receive notice. We never saw it before we got discovery through the course of this appeal. That by its very nature is a factual argument. That is a credibility argument. I'm not asking you to make that decision. I'm asking you to reverse the ALJ's order because he didn't make that determination, despite the statutes and Volunteer Princess Cruises explicitly requiring him to, despite us specifically requesting him to, and despite us, you know, providing substantial evidence saying that we never actually received this. I think I'll leave it at that. I'm sure everybody's ready for lunch.
Well, with that, we'll otherwise enter deliberations. Again, remember the options are still the same. You can affirm, or remand with instructions or reverse on whole or part of the decision. Mr. Rust, you are a presiding member. I'll hand it off to you.
Was an appraiser. I am not an attorney. This really is a legal issue. I think from a cut and dried standpoint, and I'm discussing this with y'all, excuse me, that there's no contention that somebody dropped the ball several times on this. And so I would have to affirm the ALJ's decision on that.
No, I don't. In lack of any other evidence, I think it's a fairly simple matter.
Yeah, I agree. It's especially after the dates were brung out, and I had reviewed that and seen some of that. It just cleared it up for me when I was reviewing it that they did have ample notice. And the Secretary of the State, when they, got the information from there, it looks like the state started working on that, notified them. It goes on from there, and then the CEO is really where it cleared it up for me when he basically says he's tried to combine 3 companies of trucking. I mean, that showed to me that these companies existed as a company before. And so you're just trying to integrate all these together, which made it confusing for them to who to hand the notices to, and which is not the state's fault. And they didn't respond in proper time. And so I make a motion, we uphold the administrative judge's decision.
Second.
All those in favor say aye.
Aye.
Aye. Any opposed?
Motion carries unanimously. Unanimously. That concludes our business for 10 Roads and then the business of the commission today. We will issue that final written order, just memorializing what you've heard today within the next 90 days, which will show your available appeal remedies from there, including basically once the agency decision becomes final, which is typically about 45 days after this, you can go to Chancery Court. There's like a 60-day window after it becomes final if you want to do that. But all of that will be the
I'm sorry,
administrative.
you said that we have to go to court within 45 days of today, but we won't get your ruling until 90 days from today.
Yes, sorry, it's very confusing. So yeah, let me slow that down. We have 90 days to issue just a final written version of the decision you heard today. It just memorializes it. Our presiding member, Phil Rust, will sign off on that. We issue it within 90 days. And then from there, the last page of that will have available remedies. With State Board of Equalizations, you can petition for review by the full State Board of Equalization. Their review is entirely discretionary and optional. You don't have to request a review. Essentially, once we issue that decision within 90 days, there's the date of that decision. So if it's issued on day 90, essentially, there's a 45-day optional review period. And then at the end of that period, the decision becomes quote unquote final for agency review. And you have 60 days from when that decision becomes final for agency review to appeal to Chancery Court. So there's a lot of triggering events that happen. Essentially, it's that appeal for petition for review to the Tennessee State Board of Equalization for the full board. It is discretionary. You do not have to elect to do it. You just have to wait for the decision to become final. The board has some discretionary authority to unilaterally decide to review it. That virtually never happens. Not in modern history has it ever happened as far as I'm aware. You can petition for review within 15 days of getting that final written order from today's proceedings, or you cannot, and then it'll become final, and then you'll have a window for Chancery Court. All to say, we try to make it as clear as we can. I know it's kind of clear as mud talking about it. There's a lot of dates and times and frameworks.
That makes sense. I do have one question.
Yeah.
For, I think the statute 1512 provides that penalties and interests don't incur as long as an appeal is pending. Obviously, since we cannot further appeal this for this, roughly 180-day period, what's happening?
Yeah, so the same final date, that triggering point for when your deadline window for appealing to Chancery Court begins, that is when, from that date, it's called the final result date or the final certificate date. That will be issued on our website, and that's the same date that your appeal to Chancery Court begins or opens. Is that once that decision becomes "quote unquote" final, becomes a final agency action. Essentially, for if you paid the undisputed portion, then you have, I think, 30 days to pay the balance and plus the applicable interest rate. Usually at that
From
point,
today?
No, from when the agency becomes final. So it'll be
Gotcha.
not for 90 plus 45 days, whatever, when we issue that final decision. It'll become final. And then we also send you an email just letting you know that the final results have been posted. And then that triggers a 30-day window to pay those taxes. Sometimes people work it out with the trustee because there's like a billing issues and things like that that go along. So sometimes that 30-day waive period can be waived by the individual trustees, I think, to a certain extent. I'm not going to talk about the deferred refund because that's not the case. So that's kind of how that works. But yeah, so basically the decision becomes final. It's that final result date, which is a really triggering event. The final result date triggers your appeal window to Chancery Court and triggers the payment of the rest of the tax bill, the otherwise accrued taxes. And that final result date is not set in stone. It's based upon, one, when you get the final result from today's hearing, and then two, it depends on if there's any petition for review to Tennessee State Board, and/or if the State Board were to unilaterally decide to review this matter, I would also push out that final result date. But until you get that final result date, you're right, that payments, that 1512 statute is basically still in place. You don't owe anything to the trustees or have to worry about that payment until the final result date is issued.
Okay. Thank you for that. I appreciate that information.
Happy to try to explain that more if you need to. This is also particularly weird. I'm not sure what counties you're operating in, so I'm not sure how that tax bill would operate. So you might want to call Mr. Sharp again too to talk about those elements of it. Typically we deal with one county and it's pretty simple. It's like this, what's one county trustee? But I know with 10 roads, I have no idea what that would look like.
That's exactly right, Secretary Pope, because the state does not receive any of these monies. They're allocated to the counties. So it depends on the various counties where you've been assessed in. I know that you've got Davidson.
Sometimes I might get a
Davidson, Shelby, and wherever Knoxville is, I think we've got as well. I think those are the three.
So you would have to deal with each one of those trustees, as Secretary Pope has said.
I know. I don't know how it works too with OSAP, how that all happens. So for the example for a typical county, how it would work is sometimes the trustee, I think the language of the statute is that basically are due. In terms of calculating that, sometimes it can be somewhat difficult. Sometimes the assessors will help the trustee and they'll send a bill. Sometimes I think some counties, the trustee is able to do that on their own and they'll send you a bill. Sometimes it's just expected that you pay. And so every county can be a little bit different. So usually you're just dealing with one county, but since you're dealing with several, I know it would be a little bit different. And so I don't know if the Office of State Assessed Property, I don't know if those counties rely on OSAP to then give them that updated bill and calculate that interest like some counties do with their assessors. So I basically talk to the counties and see what's up. And if it's something with the State Assessed Properties, I'm sure John will still be around.
Yes.
Well, and John, I'm going to keep fighting you, so we'll be in touch.
Okay. Thank you.
That concludes our business for today. Yeah, if you do have any other procedural questions, I'll still be here as well. So that concludes our business. I'm going to go ahead and end the call though. Thank you everyone. Thank our commission. All right, have a good day.
All right, thank you. Have a good one.